Thank you. Good morning. I'm calling the meeting to order of the Blue Ribbon Commission for the Future of the California Bar. And I'll request that the roll be called, please.
Sure, Justice Guerrero.
Thank you.
Susan Bashan.
Present.
David Boyd.
Yes, I'm here.
Alex Chen.
Present.
Charles Dungan.
Present.
Jeremy Evans.
Here.
Jackie Gardina.
Here.
Ryan Harrison.
Present.
Dr. James Henderson.
Yes, I'm here.
Esther Lee. Tracy Montes.
Here.
Joshua Pertula. Judge Glenn Reiser.
Present.
Natalie Rodriguez. Christine Rossi.
Present.
Emily Scovillato. Karen Silverman. Mylene Spencer.
Present.
Amy Williams.
Present. And also Natalie Rodriguez is on camera. She didn't mute in time. Present.
And if you could promote Josh Pertula, he's in the attendee session.
We have a quorum, Justice Guerrero.
Thank you very much. I am Patricia Guerrero. Welcome, everybody. It's nice to see all of your faces for the meeting here today, and welcome to members of the public who may be participating. On behalf of myself and the Vice Chair, Josh Pertula, I thank you for your participation here today. For members of the public, as a reminder, the Blue Ribbon Commission is charged with developing recommendations as to whether and what changes to make to the California bar examination and whether to adopt alternative or additional testing or tools in order to ensure the minimum competence to practice law for attorneys in California. During our last meeting, I think we established a good foundation for the work of our task force, and I thank the presenters again for your contributions. I encourage you also to continue to share your thoughts and perspectives, and we hope that you will find this meeting helpful as we continue our efforts to identify ways that will improve the admission process for the California bar. The general objective for today is to sort of build on the presentations from our last meeting, and we try to do it in a way that would be responsive to the feedback that we obtained from our members at the end of the last meeting in terms of the information that you wanted to see in order to help us move forward with our recommendations. So the presentations for today are designed to provide us with that additional information and really to help us with key decision points that we need to make moving forward. Specifically, you can glean this from the agenda, but the key decision points and also from our charter are whether we should adopt a California specific approach, or alternatively, whether we should sign on to adopt the NCBE's next generation uniform bar exam, which we heard about at the last meeting. And in addition, whether we adopt a licensing exam or alternatively some type of different alternative measure of competency for admission to the bar. So those are the general objectives, and at the end, we will talk a little bit about what to do with that information and how to proceed going forward. Before we begin with the public comments, I wanted to introduce or inform the group of a new member, Jeremy Evans, who is replacing Ona Dasun. I'm not sure if Jeremy is present or participating. He is the recently elected president of the California Lawyers Association. So I can't tell if he's here.
I am.
Okay, thank you.
Yeah.
Well, I wanted to welcome you, and also you missed our introductions during the first time around. So I would like to ask you and invite you to tell us a little bit about yourself and your interest in the commission's work.
Well, thank you so much, and it's an honor to be here with all of you. And as was just mentioned, I just became the president-elect. I get sworn in September, but really happy and honored to be a part of this group. And my interest, I guess, is really twofold. One is obviously as representing California lawyers through the CLA, and sort of what the future of the bar exam looks like. But then I think also in an individual sort of personal level, I think it's great too, just in sort of my experiences I had, going to a smaller law school and having those experiences and what that looked like to take the bar. So I think from those two perspectives, and I hope to be helpful, and just honored to be a part of this distinguished group. So thank you.
Thank you, and we all welcome you, and we do miss Ona, but wish her well in her new endeavor. So welcome.
No, Ona cannot be replaced, but happy to be a part of the group. So thanks again.
Thank you. I would now like to introduce the portion of our meeting where we solicit and hear from the public if there are any comments. And I just want to go over a few of the ground rules. As noted on the agenda for the meeting today, public comments aren't necessarily limited, and members of the public who wish to comment were encouraged to submit written comments before the meeting, and that would give us an opportunity to consider them in advance. And we have received the written comments from the public, and the commission thanks the participants for their submissions. I will now ask the commission coordinator to call members, or I will shortly ask the commission coordinator to call members of the public in the order that they appear. And I would remind you that the public comment portion for each speaker is limited to 2 minutes. To facilitate hearing as many members of the public as possible, we do please request that you not repeat any points that were covered by prior speakers. And to allow the commission to continue with deliberations for the meeting today, we will not be able to hear more than a maximum of 15 minutes for the total public comments. In terms of logistics, for anyone participating through Zoom video, you should have a function that allows you to virtually raise your hand. It's a hand icon, and it should appear at the bottom towards the center of your screen. If you wish to make a public comment, please click on that, again, the hand icon. For anyone who is participating by phone, you can virtually raise your hand if you press *9, again, star, and then the number 9. The coordinator, I'll ask to call members of the public in the order identified by raising hands virtually, and will enable the microphones for each of the speakers. So I'll ask him to please do that.
Okay, Justice Guerrero. I just want to remind you that when I indicate the 30-second remaining, please wrap up your comments at your allotted time. So at this time, we have the first public comment from Julian Sarkar. Go ahead, Mr. Sarkar.
Thank you. Good morning. My name is Julian Sarkar. I represent attorney applicants against the State Bar of California and the National Conference of Bar Examiners. I'm here to ask the members of this commission to recognize the overdue need to abolish the NCBE and to prevent its ongoing attempt to violate our state's conflict of interest laws. From its inception, the purpose of the NCBE has been to eliminate what it called the overcrowded condition of the bar, seeking to exclude Blacks and other underrepresented groups from the legal profession. The NCBE's attorneys dedicated their lives to ensuring that the types of clients we would represent would never see their day in court. Only in recent times has the NCBE begun to claim that it serves the purpose of ensuring minimum competency for public protection. But the NCBE's CEO and other employed attorneys who have the privilege of not taking the bar exam are living, breathing proof that their bar exams do not serve that purpose. After nearly a century of the NCBE sending its lobbyists across the nation to have state judiciaries grant the NCBE contracts to serve as gatekeepers to the legal profession, almost every system in the country uses some form of the NCBE's bar exam as a means to restrict access to the legal profession, except for the very system that produces the NCBE's attorneys itself, meaning that those attorneys who create the bar exam, the national bar exam from the NCBE, have never even tried to pass it. In the same way that the NCBE fancies itself too privileged for the requirement of their own bar exam, it also considers itself above the law here on our Supreme Court's commission and has accepted a seat where it intends to vote and grant itself a lucrative contract for administering the uniform bar exam, a crime under California law. For the same reason that Government Code Section 1090 prohibits an agent from a private prison corporation from sitting on a government panel and voting to give its own corporation a contract, Section 1090 also prohibits the NCBE from voting to grant itself a contract to run California's bar exam from behind closed doors in Wisconsin. I urge the members of this commission to cooperate with the California Fair Political Practices Commission in investigating the NCBE's unlawful conduct and bringing the NCBE to justice. Thank you.
Thank you, Mr. Sarkar. The next public comments is from Jason Solomon. Mr. Solomon.
Thanks so much. My name is Jason Solomon. I'm Executive Director of the Center on the Legal Profession at Stanford Law School, where we work on how best to educate new lawyers, which of course the bar exam impacts. A key question for this task force that I know you'll be discussing today is number 2 in your charge, whether there is sufficient alignment in the knowledge, skills, and abilities to be tested by the UBE with the knowledge, skills, and abilities required of entry-level California attorneys to argue in favor of its adoption by California. The clear answer to that question is yes, at least if we're talking about the next generation UBE, and you should not infer from New York's decision to withdraw from the UBE otherwise. New York's decision was based significantly on 3 factors not present for California. 1, the task force was operating during the pandemic and was making a judgment about the NCBE's handling of the bar during the pandemic, not the merits of the UBE itself. 2, the task force was reacting specifically to problems with a relatively new New York-specific exam, not the case in California. And 3, the task force was driven in significant part by a sense that it was too easy to be admitted in New York and that too many foreign students were being admitted. Even with the new cut score, I don't think that applies here. To be sure, there is some element in the New York task force effort of reacting negatively to what it perceives as the UBE testing the quote law of nowhere. But before you draw too many conclusions from that catchy phrase, I would suggest asking the tough questions about the basis for inferring that if only new lawyers had learned more of the intricacies of state-specific doctrine before starting practice, they would be more effective. Having read the task force reports, I can tell you there is little basis for that conclusion. As Professors Merritt and Howarth, the real experts, can tell you, the answer is not to continue to ask students to memorize rules and doctrines. The answer is to make sure they are tested on research skills and knowledge of the fundamentals, that there are local rules for courts, not what those rules are, that regulations fill in the gaps of statutes, but not what any particular state regulations say. That is the route to a better bar in Professor Merritt's report, the California Attorney Practice Analysis, and the NCBE Job Analysis. Don't let aspects of the New York report distract you from that consensus on the path forward. Thank you.
Thank you, Mrs. Solomon. At this moment, Justice Guerrero, we don't have any public comments anymore.
Okay, thank you. And thank you to the members of the public for your comments here today. We do appreciate that very much. We'll go on to the business portion of our meeting here today. And the first presentation is from Dr. Montes, and I'd like to welcome you and thank you for agreeing to speak with us again. As you will recall, Dr. Montes is the Chief of the Division of Programs and Policy Review at the California Department of Consumer Affairs. She will be speaking with us today regarding the purpose of a professional licensure examination.
Good morning, and I believe my screen will be shared with you shortly, or I should say it will be short. Thank you, Devin. Okay. Thank you. So again, good morning, and I'd like to thank you for the opportunity to present again at the second Blue Ribbon Commission meeting. I'm going to take you through a brief presentation, and I'm going to cover the following topics, which is on the next slide. A very brief introduction to the beginnings of licensure, a commonly used definition of licensure, early and initial benefits of licensure, as well as some guidelines and standards and legal basis for licensure. The guidelines and standards will be a review from presentations from our last meeting. However, they're very important, and I imagine they will be discussed throughout many of our future meetings. Then I'm going to revisit that definition of licensure, and I'm going to highlight very specific terms in that definition and relate it back to the guidelines and standards. And after that, I'll open it up to questions you may have. Next slide. Okay, very briefly, physicians were the initial focus of licensure, and that was in the early part of the 19th century. However, those efforts were not well received, and it led more to title control versus public protection. Title control is often used with like a form of registration where merely we're tracking people and maybe the title or profession that they're in. And I'll talk a little bit more about licensure, certification, and registration later on, but the initial goal of public protection was not working. So it was determined that only legislation could really restrict practice, making it illegal for anyone to practice without a license. So by the early 1900s, most states had begun to license not only physicians, but pharmacists and a number of other occupations. The next slide, please. So, and again, that was very brief, but that gives you an idea of where it started. Again, a very widely used definition of licensure, which contains key terms, is a process by which an agency of government grants permission to persons to engage in a given profession or occupation by certifying that those licensed have obtained the minimal degree of competency necessary to ensure that the public health, safety, and welfare will be reasonably well protected. Again, I'm going to talk about key terms in this definition later, but I want you to think about this as I continue on. I will specify, though, that within the employment sector, we often hear about licensure and selection exams. Licensure exams, again, are very different because they focus on minimal degrees of competency, whereas selection tends to deal with comparing individuals. I will elaborate further on those, but keep in mind, we're really focusing on licensure and not other areas. Next slide, please. So initial benefits of licensure, many of these still hold today, are that by having a license, you have a certain status and recognition. Think about how attorneys, physicians, teachers, different fields, pharmacists, and so forth. There's a certain amount of status that's associated with those titles, those occupations. Also, related to that is you have a legal identity. Your scope of practice is defined in legislation. And again, this was tied to the whole public protection aspect. Often, by having a license, you have greater economic power because there's a restriction of entry into your profession or occupation. Not everybody can be an attorney or a physician or a psychologist or contractor. There's a certain amount of protection that you have. And then, of course, the primary benefit of licensure is to protect the public from unqualified and unscrupulous individuals. And again, this is really why those legislative efforts came into play, was to make this the primary mission of licensure. And at the Department of Consumer Affairs, this is the primary mission for our boards and bureaus that regulate our various occupations and professions. Now, today, some may argue that these could have an unfair advantage, specifically number 3, the economic power. We know that in around 2015, there was the big court case with North Carolina Board of Dental Examiners versus the Federal Trade Commission. And what we found there is when you've got a board consisting of actively practicing participants in a profession, that the state really needs to govern over those decisions to avoid restricting entry into practice, making artificial barriers to licensure and so forth. So again, at DCA Consumer Affairs, we had to really step back and make sure that our boards, who have a majority of public or professional licensed individuals on the board versus public members, that they were not doing, making decisions that were unfair or could be perceived as having an adverse impact. So again, that was a really important case that came up. So moving on to the next slide, again, I'm going to go into some of these guidelines and standards that help monitor how boards and different programs institute their licensure programs. Again, these were mentioned in many of the last presentations, but I want to review them for you. The first one is the Federal Uniform Guidelines for Employee Selection Procedures, a very old document. It applies mainly to selection, which I had talked to you before is a little different than licensure. However, the courts still deem this as a credible source, especially when they're looking at adverse impact issues. The principles for the validation and use of personnel selection procedures, that's the Society for Industrial and Organizational Psychology. My background, it's part of the American Psychological Association. They give some additional guidance on how you develop tests, both in personnel selection and applies to licensure. And then the big one here is the standards for education and psychological testing. As we heard last time, there are hundreds of guidelines and standards presented in this book. However, Chapter 14 applies primarily to what they call workplace and credentialing testing. And that's where we look to find guidance for licensure, specifically exams. And again, I'm going to detail out some of these guidelines toward the end of my presentation when I break down that definition of licensure. And again, to reemphasize this, the courts do rely on these standards, and they have been presented in professional journals and so forth. So very important document. The next slide goes into some legal basis, just reminds all of us, and I am not an attorney, I don't play an attorney, but obviously what has happened in the court system is extremely important for the work that I do and anybody in testing. And so we look toward the constitutional requirements. It's often documented, again, the 14th Amendment, equal protection. Exams cannot intend to discriminate against individuals or groups. Sometimes it happens, we know that, but they should not have an intentional component to that. Due process has to do, obviously, with fairness in procedure. Think transparency in exam development, administration, and scoring. One of the things that we do at our department is we audit national exams. I've done that myself for many programs. And it's really interesting because California has a very high standard of sharing information and being transparent. And I should be specific, the California Department of Consumer Affairs. And we find that a lot of national exams in some states do hold their materials very close. And that can be problematic in many situations. We're not looking to see the exam. We don't want things that could jeopardize the integrity of the process. But if we're doing an audit or review, we need some pretty detailed information. And so there's an expectation, a professional expectation to share that information so that we can confirm that an exam meets those standards and guidelines that I talked about earlier. With regard to statutory requirements, we know the Civil Rights Act have had a huge impact on testing, again, preventing discrimination in employment settings, extending it to educational settings, and so forth. So again, lots of history there. And then just a few cases that we in my profession are always reminded of, and that is Dent versus State of West Virginia, constitutional support for licensure. States can regulate and license individuals. Griggs versus Duke Power Company. Again, in my field of study, that was one of the first things we studied in graduate school. First landmark case dealing with job-related testing. That was huge for my field because it really gave a lot of credibility to the work that we do. You can't have an arbitrary test. It has to be job-related. Chance versus Board of Examiners established that job-related precedent for tests used with public employees as well as private employees. And of course, there's a whole host of other case law that's been established to guide the work that we do. But again, for me, it's very exciting because it really gives credibility to the field of psychometric and demonstrates that tests have to be job-related, they have to be fair, and there has to be a lot of thoughtful analysis in the process. And you would be surprised how many programs out there and states have certification exams and licensure exams that don't meet these very foundational components. So, stepping off my soapbox for a moment, let's go back and revisit that definition of licensure on the next slide. So key pieces in this definition: agency of government. So it's a process by which an agency of government grants permissions to persons to engage. Okay, so that's where the legislative component comes into it. Okay, here we have our California legislature. We have our regulatory boards that put forth statutes and regulations that guide this work. They're able to engage in a given profession or occupation. That is typically in your regulation in general, referred to as a scope of practice. Now, what we do in our field is, in order to update what we call that scope of practice, is you heard the California practice analysis. Sometimes it's called an occupational analysis, task analysis. We take that scope, which is usually very small, and we do a study to really expand that and see what is done in that occupation or profession. We take a big snapshot in time, and then we say, of this big snapshot, what is most critical to test on a licensing exam? Now, I've highlighted the word certifying here. I really don't like that. That's the only term I don't care for in this definition, because certification is its own entity. It is typically something that could be above licensure or below licensure. So when somebody says, I have a certificate or I'm certified, that doesn't tell me a whole lot. If somebody says I'm licensed, that means they've met this minimal degree of competency. The certification can be above or below. But essentially, the idea is that this government gives individuals a license in a particular profession that's been defined in the scope of practice because they've attained a minimal degree of competency. Now, most people flinch when they hear that word. Again, that's a technical term in our field of psychometric. What it means is that there's a baseline or standard from which those who pass that exam, who are above that standard, can practice safely and competently. Those that fall below are not competent. That standard varies for every profession because that standard is based on what is necessary to get to that assessment, take, and pass. So, for example, in consumer affairs, we have some programs for licensure. You don't even have to have a college degree. You can have a high school degree, or you can be 18 years old. Other professions, you have to have a high school degree, a graduate degree, supervised hours, residencies, tests. I could go on. So again, every profession, that description or definition of minimal degree of competence varies. Who establishes that? Subject matter experts. Who are subject matter experts? Technically, they're those that are licensed and actively practicing in the profession. So with a testing expert, a group of subject matter experts get together and discuss how you're going to develop this degree, minimal degree of competency, this definition. What would be expected of individuals? And that again goes back to your practice analysis and a number of other documents. So you've certified them, they've taken this test, they meet this minimal degree of competency. And again, the primary goal or mission of that assessment and licensure is to make sure that the public's health, safety, and welfare are protected. It's not to educate them. It's not to ensure that they're going to be highly successful, make lots of money. That's not what a licensure exam is. It is simply to say we have granted permission for this individual to practice safely and competently, period. Okay, I'm going to go through my notes here and make sure I have talked about everything that I want to. A couple other things with regard to licensure. Sometimes you're going to hear low stakes versus high stakes. High stakes exams or licensure exams are typically those that have a huge consequence of failure. So if you fail an attorney exam or a physician's exam, that's significant. And if you were to pass and not be competent, there would be extreme consequences to the public. So sometimes you're going to hear low stakes versus high stakes. I would consider the attorney exam as high stakes. It's a very serious, significant exam. Another thing that you're going to hear about that I want to clarify with regard to licensure exams is that we're talking about, when we talk about a minimal degree of competency or the standard, you're also going to hear things like criterion-based decisions. And that's, again, associated with licensure. The criterion that's used is that minimal degree of competence. Typically in schools, the criterion is normative. Grading on a curve is a normative kind of decision. That's what differentiates licensure exams between educational exams or even selection exams. Sometimes selections will have a criterion too, it depends. But this is really important when we talk about licensure exams, because one of the standards, as well as case law, has shown we don't adjust the passing score to gatekeep. We don't go, oh, it's a little high and not a lot of people pass, we're going to lower it, or it's too low, we're getting too many attorneys and now we need to adjust it. That is not a defensible mechanism. Ideally, if every one of your candidates has met that standard, that degree of minimal competency, then you'd expect 100% passing rate on your exam. But we know that not everybody is at that level yet. So we're going to expect failures. So the idea is that your passing score is criterion reference and it reflects that particular exam at that particular time. Again, I want to emphasize too, licensure exams are not intended to educate. And this is where I have to play the bad guy with our licensing boards, because of course they want to make sure that candidates know everything before they're licensed. Again, a licensing exam represents the most critical competencies to be tested. How is that identified? Through your practice analysis. Your practice analysis will give you competencies or tasks or knowledges that should be assessed. From those, you're going to then decide how best to test those. Is it a practical exam, a performance exam, a written test? And that's where guidance of a test expert can help you. Because yes, it is possible to test cognitive, higher order cognitive skills in written exams. We do it every day at Consumer Affairs. Physicians do it, nurses do it, psychologists do it. It's done. We do see a movement though away from essay exams, away from performance and practical exams. They're very expensive. And let's go into that now in the next slide, since I'm talking about other points to consider. So a licensing exam, to kind of take us into our next discussion. Key concepts to support the defensibility. I mentioned early on, you have a practice analysis or occupational analysis, tells you what is the critical component. That has to do with validity. Does your exam measure what it's intended to? That's one of the most important concepts that you will hear. And you'll notice I put here legal defensibility. That's sort of my standard statement to my boards. I always say, is the exam fair, valid, and legally defensible? And that usually gets their attention. And so these are the things that I would ask all of you on the commission to consider. The exam that is eventually developed, the process, is it measuring what is most important for entry level or minimum competency? Is it reliable? Are exam scores stable? That is, if you test the candidate and with no intervening factors, if they were to take that exam again, would they get the same score? Standardization is also very important, especially when we're talking about online and remote proctored testing. It used to be paper and pencil, moved into some computer-based testing. Now we've got discussions of remote, thank you, COVID. And so standardization. Is the assessment process consistent for everybody? Are they in the same testing conditions? I used to count pencils. I used to do testing for firefighters. And I would literally set up the stations, count the number of paper clips, count the number of pencils, put everything in a certain manner in addition to reading my instructions. I did that because they were watching and they would say that. They would say, you even count the pencils. And I said, yes, because this is a standardized process. I want everybody to have the same experience. Fairness, another very important component that I love to share when I'm making public presentations, because it really, in my opinion, let the candidates know that, yes, it's important that we're fair. We're not trying to trick you. A licensing exam should not trick candidates. It should avoid any kind of adverse or disadvantage. I'm not even going to try to say that this morning. Impact. It's really important that we take rigorous measures to ensure that it's fair. Sometimes it's not. Unfortunately, there's a lot of literature about achievement exams. Those types of exams can have adverse impact, but we're trying, we're getting better. In licensing, in some of our boards are starting to collect demographic data, and we hope that that will help us. So we work hard to make sure that the exam is fair. Practical. This is another point that's also very important. The exam must be reasonable and cost effective. Again, working with my clinicians, my marriage and family therapists, if they could, they'd have a week-long exam and bring candidates in and do counseling sessions and all kinds of really exciting things, but that's not cost effective. And our research has shown that we can do a different kind of situation with supervised experience and a very robust multiple choice exam with clinical vignettes that does a good job at identifying those who are competent to practice and those who are not. So taking this full circle, licensure has had very early start with physicians. It's evolved over the years. We have very important standards and guidelines, as well as research that guides the work that we do. We know that there's lots of benefit, but at the same time, we have to be careful that we don't overstep and restrict entry or create artificial barriers to licensure. And as we do this, we look at these key concepts and we consider them and try to balance them out. And as we evolve and discuss these concepts and make decisions, it's very important that we consider the scope of practice for attorneys. We look at the results of the practice analysis, and we work with our subject matter experts and our individuals at the state bar, because each of these areas has very important information to contribute to the process. And each of us has an area of expertise that by interjecting that into the process, it builds up that evidence of validity. Validity is not an all or none concept. People will talk about, was the test valid? That, yeah, we typically do that, but really it's the decisions we make about the test. So I always explain our goal is to accumulate lots of evidence to support validity. The more we can address issues with regard to it being practical, fair, standardized, reliable, and valid, the more evidence we have. So if there are challenges to it, we can say, this is what we've done. And that, again, leads to the legal defensibility of the process. So thank you very much for your time. I will open it up to questions if you'd like, or later, however the justice would like to proceed.
Thank you so much. That was very helpful to understand the importance of the licensing program. I would open it up to questions at this time. Okay, I'll start with Jackie or Dina.
Thank you, Justice, and thank you, Tracy. It was a very helpful presentation. I just had one question related to the definition of licensure with the validity, reliability, standardization, fairness, and practicality. How do you weight those?
I weight them as all equally important because they impact each other. So if your test is not reliable or not standardized, it's going to impact the validity. Same thing with fairness. So they're all interrelated. And the idea is just to look at, there's various guidelines for each one of them. And so you can kind of tick off, you know, what you're able to achieve. But most programs that are thoughtful and again involve subject matter experts and a testing expert can achieve each of these within amounts to be defensible.
And just one second one, and thank you for that. Reasonable and cost effective for whom?
All of the above. It needs to be for the government agency. It needs to be something that they can administer in a way that doesn't cripple their entire budget. Many of our boards or programs will sometimes pass on those costs to the candidates. And again, it needs to be thoughtful there. Is it a barrier to licensure? Are you charging $1,000 for your exam? This is something that we look at very closely. Many years ago, we did an audit of the National Acupuncture exam, and it was broken down in components where it was extremely expensive for candidates to take. And that was one of our recommendations. There were several, why we did not recommend moving forward with that national exam, but that was one of them. It was extremely expensive compared to the state exam, which was doing as well, if not better, of a job of assessing competency. So both.
All right, thank you for that.
Mhm.
Thank you, Jackie. And Donna, you have some questions?
Yeah, I'm curious, Tracy, as I was listening to your presentation, and you talked about the benefits of licensure, what licensure is intended to control or protect, and the sort of the key elements of it. Why is it that licensure exams in particular evolved as the best way, or as the way or a way to assess the minimal degree of competence in a standardized, fair, practical, reliable, and valid way?
Essentially because there was harm being done to the public. So it kind of goes back to those early initial efforts where individuals, consumers, patients, clients were being endangered. And so that's why the decision was made to move to a more formal mechanism beyond title control to actual licensure. And so it really becomes the state's decision in terms of who and how to license a group of people. And of course, that's a very political discussion because some states regulate more than others. For example, California is the only state to license professional fiduciaries. However, we're finding that as we have a much older and aging population, and now with Britney Spears in the news, that's becoming a big deal for our little fiduciaries bureau. Other states, other discussions have revolved around barbering and cosmetology. Do we need to regulate them? Other states don't. However, when you look at the chemicals and the potential impacts to a consumer, so it really boils down to protection of public and the consequence of error. And by doing that, then the legislature puts forth that regulation to create that scope of practice, and then it becomes the individual agency to then move that forward in terms of how is that test going to be? What is minimally competent? Sometimes we also say minimally acceptable competence, but what does that look like? And that is very challenging over time. And I want to use this real quick as an opportunity to say that the federal guidelines, again, although they apply to selection, they've been adapted for licensure. They will say that you need to look at your scope of practice about every 3 to 7 years. So at Consumer Affairs, we try to look at our scopes about every 5 years through the practice analysis because things change. And so while people may say there's an exam, it's really not. In order to be valid, you should be revisiting this process regularly, about every 5 years. And that keeps you from having a passing standard that is too lenient or too severe, or having an exam that has outdated information, things like that. So really, that's the whole trick. Licensing itself isn't necessarily a bad concept. It's just how it is utilized over time and whether or not it is updated in order to meet those guidelines and standards. Does that answer your question?
It does. I have one quick follow-up. I think it's a quick follow-up. Are there occupations, professions in California that are licensed through means other than an exam?
I don't know, because I can only speak to like Consumer Affairs, the ones that I'm most familiar with, which we have, hundreds of licensed clients. We have like 244 or so. Most have an exam: physicians, nurses, contractors, psychologists. You had asked me a question about airline pilots, and I had done some research. They actually have tiers of licensure that involve taking written tests and actual flight tests, depending upon what level. Of course, when they get to the commercials or the majors, as they're called, it goes into simulation tests. But yes, even they have written tests. And what's interesting is every year they have to go through a 5-day education of, they call it like a retraining, where they have classes, they have tests and simulations. So most high stakes professions do have some kind of test that I am familiar with. I'd have to dig really deep to find some that don't have any kind of test. Again, tests are a way to really keep that minimally acceptable competence clean, that regulation, that consumer protection. Yes, our boards will allow supervision, but that's by the supervisors. They may do clinical experience, but that's by whoever's providing that supervised experience. But the test, that's usually the one tool that the agency has complete, it uses the word control, but control over in terms of assessment.
Thank you.
Mm-hmm.
Thank you. Dr. Henderson?
Yes, and do please call me Jim.
Jim, thank you.
I have a question about, Tracy, your comment on how licensure examinations should not be disadvantageous to any group. And of course, we do see sometimes systematic differences in the way people perform on a test related to, maybe not necessarily caused by, but associated with some kind of group membership that they might have individually. I'd like for you to talk a little bit about adverse impact, how that's defined, how it's analyzed in a licensure test, and anything else you might want to say about it.
Well, that's going to be a short answer because we don't actually analyze that at the Department of Consumer Affairs. We actually have a code that prevents us from collecting demographic data. So at this point in time, the only boards that are allowed to collect that do so on a voluntary basis. So we're really not able to run any meaningful statistics. But we do know that some of our national exams will look at that adverse impact, and there's a differential item functioning analysis that can be applied to look at individual questions and how they may adversely impact candidates. Some programs, and I'm just going to draw a parallel. What we may do at Consumer Affairs, well, I shouldn't say what we may do, what we do at Consumer Affairs for the exams that one of my offices develops, the Office of Professional Examination Services, we contract with many of our boards and bureaus and develop their exams. So what we do is we actually pull item statistics about every 10 days on our exams that are being administered. I'll go back to marriage and family therapists. They have an exam, multiple forms that are being computer-based tested every day. Candidates are taking them. We're pulling statistics every 10 days and looking to see if any of those exams items may be functioning in an adverse way. And I just mean that in a very generic way. If that's the case, we're going to go back to our subject matter experts and the board and assess what's going on. Is there something that's confusing in the test question? Maybe it is, again, we don't have group information, but if that's the case, we may pull the test item or give candidates credit for that. That happens very rarely because of all the steps that are taken initially. But before an exam does go out, we have an editor review that does look at various things that could have some grammar issues, some wording. We, again, work with a diverse group of subject matter experts. So maybe, you know, our candidate pool is not going to tell us about groups, but our membership of our subject matter experts, we're going to try to ensure that diverse. So as we are developing the questions, we can avoid that. So we try to do what we can on the front end. but certainly we don't run differential item functioning. That's typically what you would do. If you have issues with adverse impact, again, that goes back to your psychometricians, your subject matter experts, where you really have to make a determination of those items and questions in terms of, is there a better way to assess them? If not, and I haven't reviewed case law before, but I do believe that there is support if there are not alternative means to evaluate those competencies. So we're definitely doing better than we have in the past. We're getting there, but that's a difficult one for me at Consumer Affairs. Dr. Henderson, you may have more experience with assessing adverse impact. We know it's out there. We try to avoid it, but it does happen.
Thanks very much. That's helpful.
Thank you. Susan?
Thank you, Justice. And thank you, Dr. Montes. I believe that when you were covering your foundational principles, you made a comment that said many states have programs that violate these fundamental principles. And I wonder if you could explain, or if there's any commonality to why is that? Why do so many programs violate these common principles?
Sure, and I probably shouldn't say many. I should say I've come across more than I'd like to see. And probably the most common one is that they do not do a regular evaluation of their examination program. They maybe do it every 10 years. Their occupational or practice analysis is not up to date. Another factor that I see is that it's done in a very limited manner, as in once a year, we bring subject matter experts together to write test questions. And once a year, we bring a committee of 10 representing the entire United States to look at a particular profession. So that's where I see the violations, is they are not these these processes to ensure the rigor and validity of the exam programs are not done as often as needed, and do not involve the number of subject matter experts that should be involved.
Thank you. And the last question, Alex.
Thank you, Justice. Hi, Tracy. Are you aware of any consumer complaints against either a law firm or a company run by lawyers that is grounded on either incompetent representation, legal malpractice, or ethical violations? And if so, do you have any meaningful statistics about these complaints that you're able to share with us? I am very interested in learning about any statistics or findings that might shed light on whether competency or lack thereof might have played a role in those cases.
Unfortunately, I don't. I can check with our Consumer Information Center, which is also one of the units in my division. I would imagine if we did have an influx of complaints, I would have heard about it, given that they know that I participate on this commission, but I will double check. I imagine that given that the State Bar's website is very consumer friendly and has lots of information, that's probably where the complaints would go, but I'm happy to see if we have anything at our department that might come through CIC, because we do get not only complaints regarding our boards and bureaus, but a lot of what we call non-jurisdictional complaints. Thank you.
Thank you.
Thank you again, Tracy, and thank you to the members for your very helpful questions. At this point, we will move on to the next item on the.
On my Zoom call, so I'm going to be out of pocket for a while now. Love you. Talk to you later.
That was recorded, so you have that for posterity. But moving on to the next item on the agenda, we have prepared for discussion a mission or a value statement that was distributed in advance for discussion purposes, prepared by Donna. And we wanted to, again, respond to some of the feedback that we received. I believe Jim and Ryan Harrison suggested this, to put together something that would outline our guiding principles for what the commission is attempting to accomplish and assist us as we move forward in developing our recommendations for the California Supreme Court and the state bar. The intent is for this to serve and function as sort of a reminder, so that we keep these principles in mind as we're considering the nature and format for a bar exam or exam alternative. These are really high-level concepts, but we wanted to share them with you and to see if you had any thoughts on what's included here, and to see if we can reach agreement on these principles, or if you wanted to propose additional items for us to include as we go forward. So I'll just open it up. We have less than 15 minutes until the next presentation. And if that's not enough time, then we would welcome any input on the document at some later point.
So Justice Guerrero, if I could just introduce the document.
Yes.
So to get the process started of identifying a mission statement or guiding principles that we would use to anchor our discussions and the decisions that the commission will be making, I looked at the construct statement that was contained in the CAPA report, the description of minimum competence that was set out in the State Bar's 2017 standard setting study, which is, as you know, the study to identify the appropriate passing line. I also looked at the commission's charter. I reviewed the topics that the commissioners identified at the end of the last meeting that would have, that they would like to have more discussion about, to help really provide some real insight into issues that the commissioners believe is important to consider. So let me share, put on screen here, the guiding principles or mission statement that was posted with the materials today and shared with the commissioners. I've highlighted just a couple of things in here just to focus your eyes on this draft mission statement on the key objectives for any exam or exam alternative that the commission considers. Starting with the first bullet, would be confirming that those admitted to the bar have the knowledge, skills, and abilities needed for entry-level practice in the current environment. Building on what Tracy said, not what the knowledge, skills, and abilities were in the 1940s or the 1980s or even the early 2000s, but based on the practice of law today. Ensuring that admission to the practice of law requires a demonstration of professional ethics, because that is so essential to what we expect of lawyers. Also tying clearly back to the key mission of the State Bar, and also, as Tracy outlined, sort of the need to ensure the protection of the public. And then the last two, the bottom two, focus on the accessibility of the exam or the exam alternative. Accessibility also encompasses the idea of fairness and equity. It would include things like exam delivery methods. What types of exam delivery methods are most accessible, are fairest, provide an equal opportunity to exam takers. So sort of similar to what Tracy was talking about with the ensuring that the setting of the exam, remote versus in person, if there are less uniform settings that people are taking the exam in, say in a remote exam, does that impact the fairness? Does that impact the accessibility of performing well on the exam? California values the different types of opportunities that we provide to get a legal education and qualify to sit for the bar. So in my mind, accessibility would also encompass issues of ensuring that we don't design an exam or an exam alternative that would only allow admission to the bar to those who go to the highest of the top tier law schools, whether because of cost, access to resources, et cetera. So accessibility would sort of have that broad lens. Similar but distinct from accessibility is the impact of the selected exam type or the exam alternative based on race, gender, ethnicity, disability, et cetera, is one of the things that we had talked about at the end of the last meetings, or what exam types tend to have a bigger disparate impact, larger differential performance between test taker types, subgroups of test takers. And so really wanting to ensure that we identify and recommend exam types or exam alternatives that have the least or lesser differential performance, and keeping that as a focus. So that's what I had identified based on the resources that I looked at. I think to ensure the best use of the time that we have, instead of wordsmithing what's in front of us, what would be, I think, most useful is your input on whether there are things that are currently included in this list that shouldn't be there, and what other factors need to be added to guide our decision-making over the course of the next 18 months.
Thank you, Donna, for preparing the document and for the overview. It looks like we have several questions, and I'll just go in the order of my screen. Alex, I think you're from the last time. I don't know if you had an additional question.
Sorry about that.
That's okay. And Ryan?
Yes, thank you. So I just want to say that I definitely like these guiding principles and the mission statement. I just really had one question, and it's kind of something like I'm not too invested in, but it's something I want to point out. Maybe it's because of my lack of understanding, but I mean, overall, I know that the mission of the State Bar is public protection, but my understanding is that that involves, number one, ensuring that attorneys have the minimum competency to practice, and that they are practicing ethically and with professional responsibility. So I'm wondering if just putting the broad phrase, protection of the public is redundant and unnecessary, or if there is another component regarding public protection that I'm not thinking about.
Yeah, that's a great question, Ryan. I think it is inextricably tied into the very items that you just talked about. I think it really is sort of part and parcel of that. Personally, I think, though, it would be in light of the mission of the State Bar, in light of the fact that we know that these that licensure is about protecting the public. I think it would be a mistake to eliminate it simply because it is incorporated sort of within the definitions of all of the above. But I do think that's sort of an interesting point. I hadn't quite looked at it that way, but I think you're right. It is absolutely tied to ensuring public protection is about ensuring that you've got the minimum competence to be admitted to the practice of law.
Thanks, Tom.
Thank you, Ryan. Jeremy, I believe you were next.
Thank you, Justice Guerrero. So Donna, and I guess for the entire group, just a couple of thoughts that I had. One would be whether we want to add civility to that second bullet point based on our task force on civility that we're doing and sort of the importance of that in the legal profession. And then I guess the second question or thought I had was whether we want to define examination alternatives and whether we want to, I don't know if it's too early at this point, but ensuring that there will be some sort of exam. Those are my two initial thoughts.
Thank you, Jeremy. I'm sort of looking at two screens, so I apologize if it looks like I'm veering off to a different direction. I believe Tracy was next.
Thank you. I like these. I think they're great. My two suggestions, possible edits, would be to actually operationally define accessibility, Donna, as you did. I think that would help clarify it, maybe put some of those additional words about fairness in there. And then my other possible edit would be on the bullet above, after evidence-based, add something to the effect that also based on the standards for educational and psychological testing. I think that's such an important document to call out specifically. Maybe it's too specific for the group, but those are my two suggestions. Thank you.
It's standards for educational and psychological testing, right?
Yes.
Thank you, Tracy. Emily?
Thanks very much, Justice, and thank you, Donna. My comments are that I would leave this mainly unchanged. I think it's great. I think it's something that when I was on the CAPA working group, that we tried very hard to think through all of these aspects of what actually looking at the next step would look like, and I think this really captures it. So my request is to leave this as much as possible, and the additions, maybe we develop a vision statement over time, but to actually have a mission statement that we can get going on, I would leave as is. Thanks.
Thank you, Emily. Amy?
Thank you for allowing me to speak. I'm grappling with this page because we have guiding principles certainly that we should consider as we carry out our objectives with this commission. But I'm trying to separate our mission and what we're charged to do with this group as opposed to what is actually allowable and what is the purpose of the criteria with respect to admission to the State Bar of California, which are, in my mind, two different things, two different concepts. We have the exam and then we have actual admission and what that purpose is supposed to be. So on the one hand, I think everything on here is great, but I'm wondering if any of these bullet points should reference the exact part of the exam. This is Amy, and I'm done speaking.
Okay, thank you, Amy.
Can you give an example of what that might look like, Amy?
Yes, please.
I'm sorry, Amy, you may not have heard my question. I was
Yes, please do.
No, I was asking you if you could give an example of what it might look like to reference that part of the bar, the exam.
Well, okay, certainly. With the third bullet, addressing the previous gentleman, Ryan, I believe, brought this up about criteria for admission should be designed to ensure protection of the public. In my mind, the exam is the first step designed to ensure the protection of the public. That's how I was thinking about it, because it seems that these bullet points are really skewed towards admission as opposed to the exact, the purpose that we're here for is the exam. So I feel like there should be some reference to the exam. And I defer to my colleagues on that, but it's just my thought.
Yeah, and I appreciate that. And part of the reason that that some of the language may seem a little tortured is because today, as Justice Guerrero sort of laid out at the beginning, and we've got sort of two foundational questions that we're considering, and we don't expect to reach answers on either of them today. But two of the foundational questions are, if we go with an exam, is it a California-based exam or is it the next generation of the Uniform Bar Exam? But the other foundational question is, do we have an exam at all? And we talked at the last meeting with a number of individuals suggesting things about supervised practice, apprenticeships. We've got someone talking today on diploma privilege and a variety of those other options. And so I drafted these such that there would be that these guiding principles would apply regardless of whether we went with the licensure exam approach or an alternative that was suggested by some at the last meeting.
Thank you, Donna. That makes a world of difference for me. Thank you. I appreciate that.
Thank you. We have two additional questions, Karen and then Ryan.
Thank you, Justice. And this, we talked about this a little bit, I think, at the last meeting, but so this is really a question, which is in the first, well, either in the preamble or the first bullet. We certainly acknowledge that these are entry-level minimum competence standards. Do we want to put any language in that it acknowledges that this is to set up sort of a lifelong career of success, right? That there's some future, and that's sort of part of the protection of the public, I think. But I'm just wondering if we want to put some concepts in here that's what the understanding that it's going to set up successful lawyers in the future, protect the public in the future, because I think there's something, and maybe I'm reacting a little bit to the pivot to the admission versus the exam, which is that it seems to be leaving out or conspicuously absent sort of a continuing standard of ethics, excellence, competence. And I know that's not the exam's purpose, but should that be a purpose of admission? And maybe that gets a little bit to the definition of licensure in the first place, but I'm trying to figure out how this interacts with sort of continuing responsibility of lawyers to become more knowledgeable, more competent, and so keeping the public interest in mind through the duration of their practice, not just, and I think I may be reacting again to that same pivot, Donna, that you just described from the narrower question of the exam.
Yeah, I mean, I think it's an interesting question. I think I was thinking exactly as you were saying it. It may very well go more toward that definition of licensure, and so I'd be interested in Tracy's view on whether how much, on what the expectation should be. Right? It's right. She was very clear. Like, it's not about educating the applicant, and certainly we are assessing minimum competence because we think that this means that somebody will be able to, throughout their career, continue to demonstrate minimum competence. Is that a guarantee of licensure or a licensure exam? And so I think Tracy's input would be useful on how that works in other contexts.
Okay, I will take a stab at this. I do think, again, it's important to keep the separation between entry level and success. Success is a buzzword for me, but I was thinking about either another bullet or adding to the third bullet about something about providing for the foundation of growth in the profession. So maybe something like that. So by admission and passing, you're going to have this foundation to continue growing, and maybe that gets to the fact that they would be successful or would continue protecting the public, something like that. But success, again, because success is beyond entry level. So that's the word that concerns me. But certainly I like that about growth and competency and ensuring that in the future. So I defer to the others.
Thank you for that, Tracy. And thank you, Karen. I'm going to ask the additional commission members who have questions. It looks like there's Ryan and Leah. If we could hold off until the end of the meeting, because the next speaker has a conflict. And so I wanted to make sure that, I apologize for that, to make sure that we get started though, if that's okay with the both of you. I appreciate it. And thank you, Donna, for your presentation.
Stop sharing.
The next presenter will be based on presenting a discussion of state-specific exam versus the NCBE's next generation uniform bar exam. And I wanted to welcome Justice Shankman, who's retired from the New York Judiciary after having most recently served as the presiding justice of the Appellate Division of the Supreme Court. in New York. He is the former chair of the task force on the New York bar exam, where he served for several years. And as you know from our materials, the task force has issued now 3 reports outlining their findings. The primary recommendation was for New York to develop its own bar exam that would test candidates' knowledge of New York law, as I understand had been done prior to the adoption of the Uniform Bar Exam in New York. And at this point, I wanted to welcome Justice Shankman and thank him for agreeing to present to our group.
Thank you, Justice Guerrero. It's good to see you again, and it's good to see everyone. And I thank you for allowing me this opportunity to meet with you and to chat with you about a subject that I confess I knew comparatively little about until I was tasked with the responsibility of chairing the State Bar Task Force. You know, and I did see the proposed mission statement, and I guess your first bullet point was the measuring, called for a measurement of minimum competency. And the question that we have been grappling with, and that perhaps you will grapple with, is against what standard? Is that as against a national standard, or is that against some other standard? So I am privileged to talk to you a little bit about our experience in New York. I do have a slideshow presentation that I used in connection with a presentation of our 3rd report to the State Bar House of Delegates, but it's going to take me a few minutes to get to that because there is some background that was presumed in effect for that presentation, and that is the material that was covered in our first 2 reports. So please forgive me while I kind of go off script a bit and give you some background. Until 1979, New York administered its own bar exam. It was done under the auspices of the Board of Law Examiners, which is a group of commissioners who are appointed by the judges of our highest court, the State Court of Appeals. The way our system of admissions essentially works in New York is that the Court of Appeals is tasked with the authority to rule make on this subject, including providing for the content of a bar exam. The actual admission is done through the Appellate Division, one of which I was privileged to chair. So during the course of my tenure on the Appellate Division, I was honored to serve in connection with the admission of probably about 5,000 or 6,000 young lawyers. And I guess a point of pride is that they all potentially have a certificate with my name on it, attesting to their qualifications and character and fitness to practice. So we had an all New York bar exam until 1979, and that's actually the bar exam that I took. In the mid 1980s, we moved to a partially New York exam, partial multi-state exam. So one day was basically a New York day, and one day was basically the multi-state bar exam. And that's where we stood until the UBE was adopted in New York with its first administration in 2016. The UBE was adopted in New York sort of begrudgingly, in the sense that there were segments of our Court of Appeals led by our then Chief Judge, Jonathan Lippman, who strongly favored the adoption of the UBE. There were many others who were opposed to it, including of the State Bar and various other bar association groups. The primary reason for adopting the UBE was, according to the advisory committee reports that worked on that, was to promote portability of admission and make it easier for young lawyers who might not be familiar with where they are going to get their first job to flip from state to state. So that if I'm going to law school in New York, I can take my score if I happen to get a job offer in another UBE jurisdiction. Conversely, if I go to law school in another UBE jurisdiction and I get a job offer in New York, I can come here. Because there was a great deal of resistance to the adoption of the UBE, New York became one of the states that also had a state-specific, quote unquote, testing requirement. This is something called the New York law exam. What applicants for admission are required to do is they are required to sit through a series of lectures by video that are basically basic CLE type classes that are designed to highlight differences between what might be considered national law and New York law. There is something of a challenge element to those CLEs, because unlike in New York, where we have CLEs that require attorneys to periodically get a code to make sure you're still listening, the way these CLEs work is periodically students would be asked a question, and they needed to complete that question correctly in order to get on to the next CLE. Not entirely clear to me what would happen if you could never get past it. I guess that never really happened. Potentially you could be, I don't know if anybody remembers the old song by the Kingston Trio about Charlie on the MTA, who was riding around in circles under the streets of Boston because he couldn't figure a way out. So there was that potential. And in any event, once you took those CLE courses, you would take this New York law course. This New York law course was 50 multiple choice questions in an open book, unproctored format, and a 60% score, meaning 30 right, would be passing. As matters developed, this test was, if you want to call it that, was widely held in disrepute. The initial version of the questions were incredibly easy. Even our New York Board of Law Examiners conceded that. An example of a question would be, New York's highest court is the court of, and then you would get 4 choices. One might be apples, one might be pears, one might be oranges, and then the last one would be appeals. It was not intended, according to the Board of Law Examiners, to be a meaningful barrier to admission to practice, but simply as a way of alerting candidates for admission that New York law might be different in areas, and there are things that you ought to be sensitized to. So if you will, it was an exercise in consciousness raising more than anything else. However, the folks who took the test did not appreciate that very much. It was, as I said, it wasn't taken seriously. And in addition, it created a great deal of unfortunate experience for students. They were required to sign an affirmation attesting to the fact that they took the test on their own and they weren't aided. The fact is that because it was unproctored, students did commonly take the test together. An effort was made to try to deter that by mixing up the sequence of questions. So if I took the questions, my question 50 might be somebody else's question 40. This, of course, presumes that students were not capable of figuring that out and writing down their answers. The interesting thing about all of this is that despite the widespread lack of intellectual honesty about this, and the fact that we were encouraging people to submit false affirmations, which is hardly the way to welcome them into the practice of law, there were people who failed, which of course was a little scary that someone would fail this, but no problem, they could keep taking the test. The problems with this test became so acute that members of the judiciary and leaders at the bar commissioned a study into it. And that's where I came in as the chair of the first New York State Bar Task Force on the bar exam. And we examined this, and we came up with a series of recommendations about the New York law exam and the test in general. With regard to the New York law exam, we determined that it should be scrapped. That while that it really wasn't taken seriously by anybody, to the extent that it was serving some sort of purpose that was not readily apparent to us, and that the damage that was being done in terms of telling young lawyers that they're going to take this silly test and potentially cheat on it and then not be honest about it was too great, and that we should get rid of that. Which then left, what do you do next? So after conducting a series of public fora in all 4 departments of the state, we held one in Buffalo, one in Albany, one in Manhattan, and one on Long Island. And after meeting with the deans in person of 11 of the 13 law schools located in New York, the other 2 participated by telephone or by sending a representative in the other case. We came to a number of conclusions. That most law students who go to New York law school stay in New York, and that the advantage of portability was not what it seemed to be. But more important, we were producing a generation of law graduates who were not being properly trained to practice in New York. Why? Prior to the adoption of the UBE, the law schools in New York, with the possible exception of NYU and Columbia, all made New York law a point of emphasis. For persons who were seeking admission from other jurisdictions, there were bar review classes that focused on New York law over an intensive period of time that roughly ran the 6 weeks or so between the end of law school and the taking of the exam. And it didn't seem to be, other than cost, a significant impediment for out-of-state law graduates to gain admission. And as you may know, New York has some incredibly complicated statutes and procedures. Perhaps the most notable is that in New York, we have 13 different trial courts, which may be a record. I'm not sure that California has that many. And we were admitting lawyers who literally could not find their way to the courthouse. Many bar associations and other CLE providers were running CLE programs on basic subjects, like what court do you sue in? New York does not have a code of evidence. It has a few evidence statutes, and the rest of it is common law. New York has a very different probate code and family law code than other states. And where we saw this really reflected is that other than in the biggest firms in Manhattan, we were seeing a great deal of hesitancy in the part of middle-sized and small law firms and sole practitioners to hire newly graduated lawyers. The point being that these folks were really not prepared for practice. There is a school of thought which has a lot of merit to it, which talks about, well, let's not have folks memorize law. Let's teach them how to think like lawyers and analyze lawyers and the detail they can get by research. And there is a great deal of merit to that, but there's one problem with that. And here, the problem is, who's going to pay for that research? Perhaps the client of the large firm, the large corporation, can afford to pay a large, top 100 firm for the research time of an associate devoted to ascertaining where the courthouse is. It doesn't work so well in smaller firms or sole practice settings. As a result, young lawyers were being faced with a terrible catch-22. In order to get a job, they needed to have some experience, but they couldn't get the experience without getting the job. And we attribute a lot of this to the bar exam. When the UBE was adopted in New York, the advisory committee asserted that there would be no problem with teaching lawyers New York law because they weren't changing the law school curriculum. What we found was that, again, except for the topmost tier law schools in New York, by which I mean Columbia, NYU, and to a degree Cornell, those other schools formerly taught a heavy dose of New York law. Because law schools are incentivized for their own reasons to have a high pass rate among their students, and because students tend, not surprisingly, to be goal-oriented, they want to know what's on the bar exam. Since there are only so many credit hours in a given course, when professors were being encouraged to drop material in order to cover subjects that are tested on the UBE, they dropped the New York stuff. And so the correct law school curricula indirectly shifted. So we found that what's on the bar exam actually drives law school curricula, at least in the middle tier and lesser law schools. It probably doesn't make a bit of difference one way or the other to the elite law schools, but every place else, it makes a very, very big difference. So given a choice between having no New York law on the test at all, having this, if you lack, forgive my candor, Mickey Mouse test, or having a New York test, we thought that we should go back to the past and go back to the day of having a New York day. But we proposed to do that in our original report by giving students choice, because we were reluctant to mandate a 3-day test. We've never really had a 3-day test in New York. I understand you may have had that in California for some time, but we did not. We never did. So what our proposal was let's have the MBE, and let's have the old New York day. If you wanted to be admitted in New York, you would have to take the New York day. If you didn't want to be admitted in New York, you would not have to take the New York day. You could take the rest of the UBE. And if you wanted all of that, then you would be signing up for a 3-day bar exam. So that's where we stood in our first report, which was approved by our Court of Appeals. And that is exactly when the pandemic hit and led to our second report. And with this, I think I can go to the slides. And Judge Guerrero, you'll please let me know how I'm doing on time?
Yes, thank you.
Thank you. So if we could go to, I think it is the fourth slide. It starts with as the report was being presented. There it is. So New York originally had planned to take to administer an in-person exam. And we urged and succeeded in getting the NCBE to push what would have been our September exam our July exam into September. And we took a number of other emergency actions that the Court of Appeals approved, which is the expansion of temporary student practice orders to allow students the opportunity to practice under attorney supervision so that they could earn a livelihood and gain some experience. The Court of Appeals agreed to generally waive distance learning requirements for all ABA accredited law schools. And we opposed, as the state bar, online testing. And we also opposed a pure diploma privilege. I want to be clear about what I mean by pure diploma privilege. That is simply somebody graduating on the basis of admission from law school. And the reason that we opposed that was that because admitting authorities have no jurisdiction, and I'm not suggesting that they should, over law school admissions policies, law school curricula, directly anyway, law school grading, that there needed to be some form of standardized testing to make sure that people had a level of minimum qualification. And our Court of Appeals adopted those recommendations. However, eventually, and somewhat begrudgingly, the Court of Appeals moved to the remote exam. And it was administered 3 times. We had a remote exam administered that was provided by the UBE, I'm sorry, by the NCBE. One was the October 2020 remote, one was a February exam, and then one was the July exam just administered. So as these developments were happening, our task force continued its work. And one of the things that we received was Professor Merritt, who I understand you're going to be speaking with in part a little later on. We received her report, and we actually received a briefing from her on her report, and she was kind enough to make a presentation to us of what she thought a new New York exam would look like. Turning to what Professor Merritt's study indicated, as she can tell you better herself, there were 4 key findings that we saw, and Ms. Wong, I'm on slide 7, I think it is, which were that state and local law plays a prominent role in the work of young lawyers, that most young lawyers were likely to rely upon state and federal law, and 50% to almost to the exclusion of anything else. That new lawyers frequently engage with clients, rarely rely on memorized rules, and often assume substantial responsibility for client matters during their first year of practice with little or no supervision, which is a little frightening. I, for one, would concede that I would not have been able to handle a client matter without supervision in my first year at a law school. The Merritt study also identified 12 building blocks of key components of what lawyers need to know. You can see all 12 of them there. And that's her study. Professor Merritt's study noted that written exams assess only about half of those 12 building blocks. For example, a written test doesn't evaluate basic listening comprehension or project management skills. That multiple choice questions, while more efficient to grade, do not measure cognitive skills that lawyers use in practice. Meaning that
I apologize, Justice. We're having issues with your PowerPoints. So
okay.
It keeps continue to just going to the next slide. So I apologize. And
that's not a problem. If you want, I can just talk off it, and you can distribute it later if you wish.
Okay, thank you. I apologize.
No problem. I should add here that a multiple choice question is really very different than anything else because it gives you the answer, meaning you're staring at 4 choices, one of which is correct, as opposed to having to come up with the correct answer using your own information base. Additionally, and this goes to some of our problems with the NCBE, it is known that males, for some reason, do better on the so-called objective tests than females, and females tend to do better on so-called subjective or essay tests than males. The NCBE weights, and this gets very complicated, but they weight the objective portion of the test more heavily because they don't trust the subjectivity of the graders. So they call it, I mentioned weighting, they might call it scaling, but there is a discriminatory impact there, which they acknowledge. And in responding to this question, essentially what they said, and this is quoted in our report, our first report, well, yeah, we know it discriminates, but it doesn't discriminate any worse than it used to, which I found, for one, very disturbing, because I don't think any of us should tolerate discrimination in any form. And we should try to do something about it. In any event, so Professor Merritt thought that we ought to be trying to minimize the use of multiple choice tests. Maybe you go to short answer essays, that maybe essay questions should be open book. Candidates should be given more time to answer questions, which is an issue that I would like to come back to. And that lawyers should be required to complete clinical work as well. In January of 2021, the NCBE issued its preliminary recommendations for its next generation of exams. And one of the things it would do is eliminate the various components that are of the test, meaning the multi-state bar, the essay, the performance test, and replace it with a single integrated test, still administered over 2 days, but you would only get one score. So that kind of put the kibosh, we thought, on the idea that we could go back to the old days because they were planning to eliminate the MBE. In a subsequent meeting that we had with the NCBE, because I'm on a working group of the Court of Appeals that's looking at all of these issues, the NCBE said, well, maybe we could do the MBE, offer the multi-state again, but it's a resource allocation question, and we can't make that commitment now. The exam would be closed book. It would drop from the subjects now tested: family law, trust and estates, the Uniform Commercial Code, except for Article 2, and conflict of laws. And more importantly, the exam would be computer-based. And by that, they mean administered on computer, not proctored by computer, which is the remote exam. The exams would be proctored in person. You know, we know all the issues about facial recognition test, you know, software and all that stuff. They're not proposing that, but they are proposing that a candidate would go into a room and receive the test via computer and then answer it on computer. As of now in New York, and I assume this is true in most places when you're not in a pandemic, the test is provided to you in hard copy, and you may use a computer to submit your answers, but you're not required to do so. And the NCBE said it would take them 4 or 5 years to develop a new test. So after we took all of this information in, our task force issued our third report, which reaffirmed our central recommendation that applicants for admission to practice in New York be required to demonstrate basic knowledge of New York law, as measured by a test, a rigorous test on matters of New York law. Or alternatively, and we recognize 2 potential other pathways for admission. One is by extensive supervised clinical practice during law school after the first year, or as well by extensive study of New York law while in law school, meaning taking a sufficient number of courses with a sufficient number of New York credits and getting a sufficient score. We argued against the continuing de-emphasis on state law, particularly given the Merit study, which suggests that newer lawyers rely more heavily on state and local law. We were particularly opposed to the elimination of testing of family law, trusts, and estates, because those are bread and butter subjects that we think are important to lawyers, even if they don't actually practice in that area, because lawyers, unfortunately, with a 50% divorce rate, lawyers will know someone who has a divorce problem. Lawyers should know something about the law of domestic violence. Unfortunately, and I'm sorry to mention this as a downer, but eventually we're all going to die. And presumably because of that, we should know something about the law of the states. And probably, given the concerns with guardianship and guardianship proceedings, we probably should know something about guardianship as well, as sort of as the role of lawyer as public citizen. We were opposed to the administration of the bar exam by computer. There are studies largely being done in Europe, which suggests that reading comprehension is not as strong when people read on computer screens than it is reading in paper. That's even before you get to issues with people who have cognitive disabilities and struggle with reading on a computer. In addition, and in our last report, we have a link to a video of a law professor educating other law professors on how their students answer a performance test on a computer in a remote exam. And basically, you get a 25-page PDF of library materials that you have to read and digest in order to form your answer. You only get one screen. So you have to have this 25-page PDF in one corner of your screen. You may want to have some notes in another corner of your screen, and then you have your formative answer in another screen. So you've got these three screens going all at the same time, and you've got to answer this question in 90 minutes. We were very concerned about whether this was going to be a test of one's computer skills rather than one's legal knowledge. In addition, and this is probably an area that you might want to think about, we test almost as many, I think, law school students or candidates as you do. We test 15,000 a year. The NCBE said, well, you could administer these tests at testing centers. We were not convinced that we could find, for let's say the July bar, 10,000 seats at a testing center so that all students would have access to the same equipment. And if students were using their own equipment, then you have potential inequalities between students who have modern, up-to-date equipment and students who have older equipment. As I'm sure you are aware, some of the problems, if not a majority of them, that were experienced during the remote exam were attributable not to the exam software, but to student hardware problems. And this is not particularly surprising, because even during our pre-pandemic in-person exams, when students brought their laptops in to use, there were students who had hardware problems, ranging from I forgot to bring my power cord to, and my battery ran out, to, my computers crashing and burning on them. So we were very concerned about that. So confronted with the idea that the NCBE was going off in a new direction in 4 to 5 years, we recommended to our Court of Appeals that we take the 4 to 5 years to develop our own exam, at least as a standby measure. When we adopted the UBE, we knew what we were getting, for better or for worse. This new NCBE exam is sort of like buying a pig in a poke, that when you ask them some questions about it, they'll probably tell you, we're working on it. We have a group that's looking at that. We haven't sorted this out yet. In addition, we are cognizant of a bad experience that we had in New York when New York went to the UBE. When New York went to the UBE, it did so with only about 6 months' notice. So the law schools did not have time to react. And the law schools in New York that heavily concentrated on New York law, the Albanys, the St. John's, the Cardozos, et cetera, their students did not do as well in the shift to the UBE because they weren't being tested on what they had been taught in law school. And what's happened over time is that, not surprisingly, law school faculty is being retained and developed and recruited based on what's on the bar exam. So we felt it would be very unfair to the law schools to pull the rug out from under them again by giving short notice that we were changing exams again, that we felt that the 4 to 5 years should be used to take the time and effort to prepare our own exams and give law students and law schools the opportunity to react. It would also mean that no one who's currently in law school, who is looking at taking a UBE exam, would then have to face a different exam unexpectedly. So that's basically where we ended up and how we ended up. In response to our report, the Court of Appeals created a working group chaired by former Court of Appeals judge, retired Judge Howard Levine. I am a member of that working group, and it is expected that the working group will form its recommendations as to what to do to the Court of Appeals by the end of the year. Judge Guerrero, am I okay on time?
We started a little bit late. We have just 4 minutes until the lunch time, but
Okay.
I'm
I'd be
sensitive
happy to entertain any questions that anyone has if they would like.
Thank you. And thank you for your presentation. It was very helpful. It looks like we have a question from Judge Reiser. Or Reiser, I'm sorry, I never get your name right.
So Justice Shankman, thank you for being here. Appreciate your time and your comments. So I have a couple of questions. The first is a little obtuse. Does New York have a law on reciprocity?
Yes. We permit anyone who's been admitted through the highest court of a sister jurisdiction with 5 years of experience to vouch in. One of the things that we would tweak is we would keep the New York law exam for those persons.
Okay, and my next question relates to the New York exam itself. Does New York traditionally, as part of its bar exam, give what we in California call a practical exam, a practice exam, or is it more of just being able to relate law school material and complex questions into an essay response?
The traditional form of exam was your basic multiple choice and essays. We do have requirements in New York now for some clinical training, but we would go beyond that, as I said, by encouraging an entire new pathway for admission that could, without a bar exam, that would go solely through supervised clinical practice for this during the second and third year of law school.
So you probably just answered my last question, but if you combine the uniform bar exam, which has its functionality, right, with a localized practice exam, would that be the functional equivalent of what you're considering as your law school alternative?
No, because that's still, you're still talking about basically an academic exercise as opposed to a practical exercise. What you're describing was what our original report had called for, which was take the NBE, take the New York test if you want to be admitted in New York as your second day, take the rest of the UBE if you wish. That's what we had been sort of looking for. The problem with the UBE, and this is something we ran into during the pandemic, there was a sort of a great deal of student agitation for diploma privilege. I'm sure you heard about that in California as well. One of the students who were aware of our first report, and they were saying, why are you making us take this stupid test that has nothing to do with practice in New York? You're just making us take a test for the sake of taking a test. And I have to concede that that argument actually had some merit. But we were not yet prepared to let go of the test entirely. But the test, the UBE tests things that are of limited to no utility in New York. The classic example is it tests, and I guess it's going to stop given their recommendations, but it tested the Uniform Probate Code, which I think has been adopted by maybe a handful of jurisdictions, and a couple that have them have conflicting provisions, which could lead people into trouble. So that's an instance actually where knowing a little bit could actually be harmful.
Okay, so thank you. Thank you.
Are there any other questions?
Can I add one more thing, Judge?
Yes, of course.
The other advantage that we saw to having a state-specific test was being able to have our own flexibility in terms of what to test. One of our law school deans, Dean Boise at Syracuse, has pointed out that there are important subjects that the NCBE does not now test. For example, immigration, health law, cyber. That, and while those might not necessarily be viewed as core subjects, having our own test would give us the flexibility to adapt questions into those areas that may well be relevant. Now, so shouldn't a student who's about to enter the world know something about health insurance law? Shouldn't a student who's about to enter the world know something about the law of immigration? These are subjects that we live with every day. And the idea is that if it's not on the bar exam, many students will not learn it. It's an unfortunate but sad fact.
Thank you. We have additional questions, Leah.
Yes, thank you.
Thank you.
Justice Guerrero. And I appreciate being able to join today. I, of course, am not on the commission, but I am the new executive director of the state bar. New and returning. And so this is my first opportunity to participate in a commission meeting.
Thank you for being here.
Yeah, thank you. I was interested, Justice Scheikman, in a few strands of your presentation. The first being the comments about remote and computer-based testing. It was interesting to me because during the California practice analysis and some of the work we've done in recent years to reassess what we are testing, there's been a repeated refrain about the need to, in fact, ensure that attorneys have a sufficient level of technological capability to the point where there was some discussion about whether or not that should in fact be tested on the bar exam. The idea being that in 2021, 2022, an attorney does in fact need to be fairly comfortable with the computer and in fact be able to do work, research and other things on the computer. So I was interested to hear a little bit more about the rationale for being sort of very opposed to that in New York.
Well, we're not opposed to students knowing about computers. And in fact, as somebody used to teach in law school, although I haven't in a while, I think everybody I saw in the classroom always had a laptop and was taking notes with it. But what we were concerned about particularly was taking a timed high stakes exam using a computer. That unless you had a way of leveling the playing field, it could create significant disparate impacts based on finances or cognitive developmental issues, because we don't all think the same way, we don't all read the same way, we don't all write the same way. And when you put that up against a timed test, it creates problems. We would not be opposed to it for all time, but we were concerned that the NCBE had not studied this before they went to this determination. Remember, their determination was issued in January of this year. The first ever remote exam was administered in October, and there's no indication that this issue was studied. Secondly, we would be very interested, and this is something that the working group is looking at, in trying to develop some form of research test. Because presumably one of the things that lawyers need to be able to do, even if they're not memorizing the law, is to how to find it. The problem with that is the devil's in the details, because there are students who may be more facile with Westlaw or Lexis. Then you create economic issues. Who's going to pay for that? And what public databases are available that lawyers could research from. So we are cautiously looking at developing some form of research exam which would have to be done using a computer, but we're doing so very cautiously because we are aware of the potential for unfairness based on economic circumstance and these other considerations.
Great. would you mind if I ask one more question, Justice Guerrero?
No, go ahead. Thank you.
Okay, and you kind of helped me segue there when you mentioned the research, and you talked a little developing a research component. You talked about Professor Merritt's work and its impact on your group, and one of your comments had to do with the value or lack thereof of a multiple choice component of the exam. And I was wondering, is New York contemplating, or is your recommendation that be eliminated altogether and just looking at essays and maybe more of a performance test? And if so, what has the thinking been around calibration? Because of course, that's what I think how the NCBE really uses that multiple choice component.
So to broad strokes, one of the things that we don't agree with the NCBE on is the notion of relative scoring. So for example, as we understand it, and the NCBE seemingly has agreed, if you take the UBE in New York, you're graded against the other people who take the UBE in New York at the same time you do. If you take the UBE in Idaho, you're graded against the people who took it in Idaho at the same time you did. So it's possible that two separate raw scores may come up with, may result in two different actual transmuted scores. Apart from that, because they weight the scores, you have a circumstance where somebody could be the best of the worst and get admitted, and somebody else could be the worst of the best and not get admitted. We would prefer to see objective, absolute grading, meaning somebody either has minimum qualifications or doesn't. And if, God bless, everyone who took the exam did, that would be a wonderful thing. If everyone who took the exam didn't, that would be concerning, but not necessarily a bad thing if the test was really fulfilling its mission. So that's one issue. The other issue is multiple choice questions are good in helping get coverage, meaning it's very hard to design a realistic, practical essay that covers a wide range of subject matter. So there is some value in multiple choice questions as long as they are not too heavily weighted towards remote memorization. And we would prefer to see more short answer type essays where someone might be given a choice, but then have to explain how he or she got to that choice. Or maybe one of the choices would be none of the above, and that they would have to explain how they got to that choice. And what we are, and I don't want to speak for everybody on the working group, because this is one of the issues that we're sorting through, but we would sort of be of the view that if the multiple choice component or the objective component was weighted 50% of the grade, and the essays were weighted 50% of the grade, we would not cross-check each other, meaning we would not penalize someone who did very well on the essays because they did poorly on the objectives. That we think is unfair, particularly knowing what we know about an historic gender discrimination there.
Thank you. And Natalie?
Thank you, Justice Streichman, for your time today. In an earlier presentation, we heard how considering the cost of the exam was important in designing or coming up with a new exam because it could relate to issues of fairness. I didn't see any discussion in the reports about the cost of any of these recommendations. Is that something that your group thought through, or was your goal just to come up with an exam that mirrored what you wanted to see in a new attorney, and then the cost analysis part would be down the road?
Well, cost analysis is very tricky. New York's fee for taking the exam is one of the lowest in the country. It was, I think, last raised in the 70s. And there's a practical political reason why that's happened. Our courts are a part of the state budget. And so the state budget, the state general fund pays our expenses. And if we generate revenue, which occasionally we do, such as, for example, TV shoots, renting courthouses. That money goes to the general fund. So the general fund funds the operations of the Board of Law Examiners. The Board of Law Examiners back in the 70s wrote its own exam, and cost was not an issue. Grading was done through a trained cadre of experienced, mostly retired lawyers on the essay portion. The Board of Law Examiners has a staff that can do this. We believe that they probably would be able to do this within the overall context of the judiciary budget. But I think there are those who would support an increase in the fee if they were convinced that it didn't go to the Department of Motor Vehicles. One of the concerns that we always have in New York when you talk about raising fees is what the legislature will do if you give them an idea of a funding source that they had not yet considered. So while we would support the idea of at least something of a fee raise to match what sister states are doing, because we acknowledge that ours is very, very below what everyone else is charging, we would not be willing to do that unless that money came back to the bar admissions process. So that's kind of a complicated but practical reason why the cost issue is, shall we say, not front and center, because we didn't want to give anybody ideas as to how to raise money. The last time New York, we came up with the idea that filing fees for civil cases should be increased. The legislature increased it and then took all the money.
Thank you. Thank you, Natalie, for that question. And I wanted to conclude and thank you, Justice Shankman, for accepting our invitation to speak with us. It was very helpful to hear from you and your experience with a New York's bar examination. At this time, we'll go ahead and take our lunch. The lunch break goes through 12:30. So we'll see.
Thank you very much for having me. I wish you well, and I look forward to hearing about how you fare with dealing with these interesting and difficult issues.
Yes, thank you very much.
Thank you very much. Bye-bye.
Bye-bye. Welcome back, everybody. We're back in session for the Blue Ribbon Commission. And I wanted to thank Dr. Bolus for agreeing to speak with us again. He requires no introduction from our prior presentation. We're happy to have you back to discuss with us the psychometric implications of developing a bar exam in California that does not have the multi-state bar exam component. So I'll turn it over to you. Thank you.
Thanks, Justice, for the opportunity to speak with you again today. I did want to find out whether or not you all got a copy of my presentation with your minutes or with your agenda.
Unfortunately, no.
Okay, that's fine. I just wanted to know if people had the opportunity to look at it.
We'd ask if you can share it with us afterwards. We'd appreciate that.
Yeah, that's great. So to assist you in your deliberations, Ms. Nunez asked me to expand a bit more on the configuration of the current exam and focusing a bit more on how the current structure came to be and some of the processes that got us here. And is one of a couple of psychometricians who has worked with the state bar over the years, and now the one who's been here the longest. I was hoping that I could share a perspective that members of the commission who haven't been around too long or not knowledgeable about psychometrics might not have, and add just basically some context to what's going on. So I'd like to briefly address methods that have been used to credential and license individuals. You've heard some of this before from the other speakers. And the criteria that is used to determine the efficacy of some of those procedures. So a lot of this is not new to you, but I think it's important to have the context. And what I'd also like to do is discuss the changes that have taken place over the past 40 years on the California bar, and give you kind of a general idea of the processes that the state bar has used to decide on these modifications. And there's a little bit of a precursor to some of that discussion, some of what Ms. Montes had said about modifications and documentations on the efficacy of the exam. I think California has a pretty good track record on this. And finally, what I'd like to specifically address is one very important modification that's currently on the table, and that is of eliminating the NCBE. And I'd like to look at that in the context of its psychometric implications and some potential alternatives. I'm not going to be able to give you exact recommendations or suggestions, but just maybe general categories for you to be considering as you go through this. So you've heard from several of the other speakers that proficiency and minimal competency can be determined in a lot of different ways. Well past written examinations, writing samples, video performance tests, recommendation, mentorships, computer simulations, even completions of certification programs, all can serve to serve as a method of assessing minimal competency. But the overarching guideline for deciding on which method is to use is to start with the content. And the state bar has gone through significant effort to establish through the CAPS program, the basic content that the new exam should be covering.
Roger?
Yes.
Roger, I don't mean to intervene, but I don't think your screens are advancing. We're still on the cover title. So do you need to, do you need help with the PowerPoint or was that intentional? Have you not started the PowerPoint?
No, I actually have.
Okay. Okay, there we go. Thank you.
All right, let me try. So Amy, if you could let me know whether or not this is changing again, you may have to advance, play it at your end. It's shifting on, it's changing on my end.
Yes, it's been a challenge today. So yeah, I'll let you know if you have any problems because then I'll help you.
Okay, did you see the word validity pop up here?
Yes, we did.
Okay, great. You've heard maybe ad nauseum at this point about the testing standards and the cornerstones of evaluating the efficacy of tests, and that actually applies to methods as well. When we look at validity, we ask the question is, does the method assess what it's supposed to be assessing? When we look at reliability, we ask the questions, are decisions stable and consistent coming from the use of these methods? When we look at fairness, you've heard a lot discussed about fairness, does the method result in decisions that are fair to all subgroups? And is it cost effective? In other words, is the cost appropriate? And do the methods result in timely decisions? I don't think that these can be overemphasized in a lot of the discussions that have occurred so far and the changes that have been proposed, such as in New York State, in the exams being offered through Consumer Affairs in California. These are act as a bit of a Bible to evaluate whether or not those changes are acceptable and will they stand up to scrutiny. When we have made changes since '79, the exam itself hasn't remained stagnant. When we look to see areas where they have been modifications have been made, both methods and formats have been modified. The testing time has been adjusted. The amount of time that we've allocated to test sections, the number of questions per section, grading practices, scoring rules, all of these have been assessed over the years. And I think Amy might have in her initial presentation given you a little bit of a timeline with where and when some of these changes have been occurring. But the one thing that I did want to point out is that the state bar has either implicitly or explicitly utilized the model for evaluating modifications to the exams. And this is a general model, but in the 30 some odd years that I've been engaged with the state bar, there are commonalities to every change that's been implemented, whether it's been in the content of the examination, the structure of the examination itself, or the outcomes. The idea has always been that before changes have been made, they're rather rigorously studied and evaluated for their impact. And the reference point for that impact has always been the previous version of the examination. It was always important in making these changes to have some advanced sense of what might be expected if the examination was to change. And those standards or cornerstones always served as the criteria. We always ask the question, what would happen to the reliability of the exam? To what specific subgroups might have had might have been affected by the changes, either doing this using historic data, or in some cases actually experimenting. California was a leader for many years in experimenting with modifications to the bar examination. And then what we would do is always compare the expected outcomes of those changes to the actual, because one never knows what's going to happen when there's always untoward outcomes out there on the horizon when one expects one implements a change. So after analysis, the final step was to publish those modifications, get stakeholder input, and assuming that there was it was acceptable to parties, was to decide on a schedule for implementation. Now, I understand changes to the bar examination will generally require at least a year or two. I'd have to get the actual time frame from Amy, but it was my understanding that because it has the bar examination has such an impact on curriculum and instruction, it's very important to provide enough lead time so that all the stakeholders can respond. And finally, the state bar always will take a look at, after the changes have been implemented, to reevaluate what the impact was. Sometimes for putting something into practice, there's surprise outcomes, and there would often be a reevaluation and sometimes some rejiggering. So if we look at the major modifications that have taken place over the years, we can see that the methods back in the late 70s and very early 80s, we had an essay-only examination. It was followed by the use of an essay and an MBE. And then basically in 1981, 82, performance tasks were added to the tests. And I'll review some of the activities that took place to add performance tasks into the current examinations. You'll notice the number of written or constructed response questions have dropped significantly from before the 80s. We started with 20 questions, went down to 12, 9, 6, and now we only ask 5 essay questions. And our number of performance tasks went from 0 up to 2 and down to 1. All of these were studied quite rigorously, and the various combinations of the tests and its configurations were looked at in tandem so that we could assess the impact on reliability. We've done studies on the number of graders per question. There was always a concern that having too many graders could lead to sources of error or unreliability. So we did go through simulations over the years. And as the pressure for getting results out faster were placed on the staff, these studies ended up determining that we could use upwards to 16 graders per question without having an adverse impact on reality. In the process of looking at the moving to a shorter examination, one reason why, and I know this is somewhat controversial in the areas of people who don't believe that the written examination has a place, or the multiple choice has a place here, you can see that the weighting was originally a 65% on the written. We moved to 50%, which allowed the reliability of the examination to remain as high, or if not a little higher than previous versions. Grading decisions, grading and decision making was also modified. back in the day, all written questions were graded, and in the early 80s, a sequential grading process was implemented, which again, again, making an effort to finish grading faster, the sequential grading process allowed for a grading of not all of the essay tests, but just a handful of the questions. And then based on the scores, people might pass on the basis of just a handful of questions. And then subsequent grading would then look at the balance of the essay questions. We went to phase grading in the mid 80s, started with 3 phases, and then just recently established that we could save over a week of grading by eliminating the 3rd phase of grading. And passing standards changed as well. And just recently we moved from 1440 to 1390, and we continue to evaluate what the effect of lowering that score might be in modifying the regrade ranges. So the other commonality among these changes is that they have been somewhat piecemeal, and they were always responding to the most critical issue facing stakeholders at the time, be that the law schools or the Committee of Bar Examiners. And for the most part, the data we used to evaluate the modification came from historic bar examination results. So deep in the library of the articles that Ms. Nunez has provided is a series of reports that documented the last major experiment conducted on the California bar examination. And the nidus for this actually came as a response to the 1979 version of your Blue Ribbon Commission. The commission at the time was concerned about the content coverage of the exam, the scope of skills that were being measured at the time, the methods that were being used, the length of time it was taking to both sit for and score the examination, and the passing rates and discrepancies between minority groups and other demographic aspects of the applicant pool. So if this looks familiar to some of the concerns that you have now, know that this has been looked at, but it was looked at some time ago. The activity was jointly funded by the California Committee of Bar Examiners and the National Conference of Bar Examiners. At the time, it was determined that cost savings and the time to complete these activities could be realized by working jointly. So the experiment was implemented during July 80 bar examination as a total voluntary program for the applicants. There were 2 types of experiments run. One was the special sessions, and that was administered on the 2nd morning of the 3-day bar examination. And with the advance notice that went out about these sessions, almost everyone who sat for the examination during that time volunteered to participate. And for the special sessions, applicants were randomly assigned to different test formats, including newly written research tasks. They were specially constructed multiple choice and essay tasks that varied both in content, question length, time allocated, and placement. The second experimentation was the assessment center, and that was administered over a 2-day period following a 3-day bar exam. And because of the cost of putting the assessment center together, a well-designed sample of about 500 applicants out of 4,000 applicants who participated. And in the assessment center, the participants took several written and oral tasks functioning as counsel for the plaintiffs and defendants. And the tasks were videotaped for later scoring. So the assessment center was basically one of the early efforts to look into, using technology available at the time, alternative ways to get at some of the content that was felt to be missing from the exam at the time. So these were the questions, these were just a sample of the questions were asked. Was performance on a multiple choice test affected by the amount of time? Similarly, for essay questions, if more time was given on an essay, would the performance be higher? To what degree would performance change if same legal skills were measured by essays or multiple choice? We're hearing a lot of discussion about, well, we can only get at certain skills testing on multiple choice versus essay. But the question really that this begs is the legal knowledge that's being tested, is one able to demonstrate performance in an equivalent manner independent of the format? And finally, could a research task, which is the current performance task, be added to the examination so that it would assess unique skills that were not captured in an essay or multiple choice test? Would it impact who passes and fails a bar examination? And we asked questions about fairness. Would it narrow or widen the gap in passing rates among racial ethnic groups? So documented in those reports are a series of findings, and here are the key ones. We saw minimal to no impact reordering questions or giving more time to answering multiple choice questions. There was minimal impact. There was some, but it was minimal from giving more time, increasing by almost 60%, to answering essay questions. And if there was any differences, they weren't related to the examinee's demographic characteristics. We discovered that the same content could be offered via multiple choice or essay format without impacting examinee scores. In other words, this meant that applicants who had the skills and knowledge required to do well on MBE items also tended to have the ability needed to do well on essay questions. Now, we do know that there's some built-in demographic changes that were alluded to and identified in New York. The question was how much was there, and was it really a material difference? And we continue to see some of those now. And we did discover that a research task or the performance test could be asked and answered, that they could be effectively offered with differing content, meaning that we could develop alternate forms, and they could be reliably graded by readers. Through experimentation in the design of the session, we were able to compare graders looking at essays and looking at performance tasks, and we discovered that there'd be no impact on reliability. We knew that the PT scores were related to the GBX scores at the time, but they did provide unique information. And when we queried examinees about what they felt about the performance task, they felt that it was a better measure of their ability to perform as a lawyer than the CBX measures. That was the measurement at the time. So you all know what has came out of this is that the research task was implemented in '81, but I do want to emphasize it was implemented after a very thorough investigation. Now, the assessment center looked at the feasibility of constructing measures of clinical skills. And clinical skills, as I alluded to before, looked at ability of the applicants to interview, to take depositions. So simulating real life situations. We asked, would the applicants who scored well on clinical tests also do well on the exam? Were they more or less proficient on the clinical skills test than on the bar exam? We asked a validity question, is that were scores on this clinical skills exercise related to the applicant's legal training and expertise? And would use of the clinical skills test on the bar examination narrow differences in the passing rates that existed among the racial ethnic groups? So what came out of the assessment center was that it was possible to construct and implement reliable forms of oral and written versions of a clinical skills test. The order of presentation of the skills didn't impact performance. And we discovered that oral and written scores on a clinical skills test were more highly related to each other than on CBX scores, which spoke to the validity of these instruments. Our analysis showed that performances on the clinical skills test could be reliably measured and graded with either oral, written, or both methods of applicant responses. We did discover, again, a validity, a bit of evidence for validity is that applicants with prior clinical practices did score more highly on these instruments. And again, the clinical skills test didn't either narrow or widen the score gaps between ethnic groups or gender that were seen on the bar exam. And finally, we determined that after scoring, that addition of the clinical skills test did not affect the passage rate on that exam, but it did affect some small percentage of people who might pass or fail. So I offer that to you just to let you know that this will not be the first time that California has considered alternative formats for a bar examination. And also to let you know that that activity basically took close to a year of preparation to plan for, a lot of effort. But the outcomes coming out of that were solid, they were defensible, and they offered a lot of fodder for the committee and the national conference of which to base decisions about making changes. Now, I'd like to move attention to the MBE component. I know that's on the table, and it would removing the MBE at this stage would probably be the most significant change to the examination since the 80s. I think I might have presented this slide last time we spoke, but the psychometric impacts of just simply eliminating the MBE and doing nothing else to the exam would impact a series of issues with respect to the examination. Ensuring year-over-year comparability of scores in the absence of an MBE would clearly impact the fairness of the test. There would be no way of establishing the equivalence of scores from one year to the next. I know people feel as though an essay test only, an essay test could be written at the difficulty levels of the questions could be made comparable, the grading could be made comparable. I have yet to see that demonstrated in any of the states that I've worked with that have tried to do that. Weighting sections on the examination would have to be revisited. It's the same level of psychometric accuracy of the overall scores would clearly be impacted. And there is, I would predict that there would be unknown impacts on the construction of written questions, grading rubrics, and grader practices, knowing that the grading of the examination of the written scores would possibly be the only assessment of the applicant's performance doing it. So one of the points, one of the things that Amy asked me to consider is, what might be alternative configurations of the examination if we were to do it. One obviously is returning to a totally, we call it constructive response, which is a written only examination. We did evaluate the possibility back in October of 20 when it appeared as though at one point we might not have the NCBE to rely on. And our estimates were that we would have had an extremely difficult time achieving the same level of reliability. One is we didn't have enough essay questions in reserve. Also, we would have needed more essays than to test more essays than the time allotted was. Doesn't imply that they couldn't be reconstructed in the future to do that, but it's a significant effort. You could supplement a written exam with new testing methodologies, adding video simulations in there to basically improve the reliability of the exam, but you still end up facing, in the absence of an MBE, that capacity to calibrate over time that Leo was talking about earlier. You could always supplement the written exam with new testing methodologies, and what has been discussed is a California developed multiple choice test. Time allocations would need to be rejiggered, but it's a distinct possibility. You could simply maintain the current configuration, but rely on the California developed multiple choice instead of the MBE. So as opposed to going out and testing new methodologies, you just substitute a California-based test for the MBE, or some combination of the methods up above, or you could eliminate the CBX completely and rely on some other licensing approach, which I understand is on the table. So in closing, just want to point out a few of the pros and cons of maintaining the multiple choice format. What's in parentheses indicate the standard cornerstone that's addressed by the pros of the multiple choice content. It's clear that you can cover a much wider range of material in a shorter time. You can include a range of difficulty levels from extremely easy to extremely difficult, helping to differentiate the applicant's performance. You have a capacity to test knowledge and some application skills, and the question then becomes how much of each do you want to assess. There's clearly an efficiency and cost perspective by grading, which is performed electronically. Questions can be repeated over time because, with a large enough test, the capacity to memorize every item is pretty much impossible. You end up with, in terms of unit time, it's pretty well established psychometric fact that per unit of testing time, a multiple choice format will yield higher reliability than other methods. And as I mentioned before, it does serve as an objective anchor between administrations. The one activity that NCBE engages in when they do their equating of exams. And the cons, I think we all know, it's difficult to develop good items. It doesn't effectively test issue spotting, which is a key skill that lawyers need to possess, and et cetera. I think these are pretty well known. So if in considering replacing the MBE with a California multiple choice test, there's a series of advantages and challenges. The advantages, as I see them, is you have much greater control over your test content. You can determine your test length by the number of items that you include. You have options for alternative delivery methodologies, whether or not you want to include, do them on a computer platform or not on a computer platform. The alternative becomes your own. You have a possibility to offer the test more than twice a year as the constraint from NCBE. What it does is it continues your current testing methodology and that you maintain standardization. You're ensuring your score comparability over time, and you're maintaining the acceptable levels of test reliability if you can produce a high quality test. And should you decide to make other modifications to the examination, you would have more control of making your own multiple choice test much more fungible. Now here are challenges, and these may be obvious, and I think Amy and Donna might be addressing some of these. Cost is pretty much item number one. I don't know if California is configured the same way as New York is that they can go in and find funding to do this, but this is an arduous task. Finding and creating a qualified development team could be a challenge. Clearly, the length of time to develop and implement something like this will be of concern. Ensuring that you've fully evaluated what you've created and doing it the right way coming out of the chute will be a challenge. Also, the need to create an organizational infrastructure. You should not underplay the amount of effort to go through the entire set of processes, which have been pretty well documented over the years, that what makes for a quality multiple choice test. And the other challenge is, as states tend to diverge in their testing, in the absence of a common test such as the MBE, the challenges will be to determine the actual relative ability level of an applicant moving from one state to the next state. So very quickly, these are basically all of the steps that the state bar would need to go through: developing content, publishing draft content for review. You have gone through some of that with your CAPS program, going through the effort of determining types of items to be used, creating item maps to the methodology, getting prototypes together, et cetera, et cetera. All the way out to creating study aids once you have all of this together. This is a kind of a full tilt system that would need to be in place to do a quality job. And I just put this out here in closing. Last week, the National conference put their timeline together to show what the timeline will be for their coming out with their next gen bar examination. You'll notice the first couple of tasks they talked about were ensuring that they've hit the cornerstones during their test development, delivery, and scoring. This is, it's not an undertaking for the faint of heart. Their estimate is basically, I think, a judge had indicated correctly, this is a 5-year process to do. Whether or not California could engage in its own development process and do it any faster, I think you have to consider this relative to the fact that the NCBE is a testing organization. That's what it's in business to do, and its infrastructure is built around that. The state bar has its own mission. Part of that mission is to administer a high quality examination. And so with that, I'd open up to some questions.
Thank you, Roger. Are there any questions from the group? It looks like Natalie, we'll start with you.
Short question. Hi, Roger.
Hi, Natalie.
To maintain the benefits that you've outlined that we have from using the MBE, how many questions would a multiple choice portion of the exam need to contain?
Well, I looked at that when we were faced with the possibility of not having the examination last October, and my estimates were, and they came out to be pretty close, is the test that we were given, eventually given by NCBE, contained 100 items. And that, my estimate was that we would approach the accepted level of reliability for a high stakes test, but we weren't quite there. It's amazing how rapidly it falls off after 100 items, but it doesn't drop too quickly between 200 and 100. So there might be an opportunity to shorten the exam, but there's other considerations such as equating how many items would need to be replicated, et cetera, et cetera. But 100 items get you pretty close.
Thank you. I just wanted to follow up on one thing that you mentioned, Roger, from your prior from the prior work, that there was a minimal impact of giving more time to answer the multiple choice questions. I was a little surprised by that, and I was wondering what the difference was in the amount of time that was provided and looked at.
There was the way that was assessed was in the special session, a 50 item test was given to two groups of individuals. I think it was 50 items. This is going back, you have to understand, 40 years, and I hadn't looked at those papers in a long time. I was just getting out of graduate school, as a matter of fact, at the time. But two sets of 50 items were given to randomly assigned groups under an extended period, and the NCBE different at the time, the amount of time that was allocated there. There were differences. I didn't want to. I don't want to down. I don't want you to come away thinking that, oh gosh, we can shorten the time or expand the time without an impact. But basically, after we made the comparisons, there was about a 3 raw score point difference. I think it equated to, in the full exam, about a 5-point difference doing it, which could be a lot. But after we went through and corrected for the fact that it was a shortened test, we looked at the reliability. The differences were amazingly small. So, and basically what that told us is that the the capacity of the multiple choice exam to get at the core competencies under the time, and I know people feel as though it's an extremely time constrained amount that's given to applicants to respond to 200 items. The differences were extraordinarily small, which was a kind of a surprise to us at the time as well. We thought that the time effects would be much larger than they were.
Okay, thank you. Susan? Susan?
Thank you, Justice. Sorry about that.
That's okay.
Sometimes Zoom is slower than my mouse. Thank you, Roger. I wonder if I could ask sort of two related questions along the lines of the year-to-year reliability that we rely on the MBE to provide us in that comparability. I have two related questions about that. The first one is, I think there is at least some acceptance that there are flaws in the MBE in terms of it advantaging and disadvantaging certain groups, whether it be by gender or other categories. And is there a way, in my mind, we cannot separate these things, that if we want that year-to-year reliability, we must accept those flaws and those advantages and disadvantages to certain groups. And if I'm wrong about that, I would like to have you explain that to me, because it seems to me they're related. And along those same lines, do we have any expectation that the national conference has indicated that they intend to replace the MBE with a different type of exam? And if they so do, are we safe to assume that we will be able to use that new exam that they are going to create and have this same level of year-to-year reliability, or will we be taking that as an item of faith?
Okay, two questions. Let me take the first one, the question about group differences on the examination. The reason why I always express the cornerstones as balancing bars is that there's no one perfect test, and there's always trade-offs to constructing a test and evaluating it. We look at group differences every examination. We produce a technical report every exam to keep our eye on the performance of the exam. The differences, there are differences by gender, there are differences by race, but the gender difference is not as large as everybody indicates it is. And it is balanced out by having the written section. So in a sense, you know, you're kind of robbing Peter to pay Paul by having multiple methods involved in the examination, one that favors one group and one that favors another group. I think that that pays service to the fact that there are differences, and at this stage is kind of the best way to balance those two out. With respect to what NCBE is going to do, they could have, they may implement a whole series of different approaches, different methodologies. I don't know what they are. I'm not on their commission. I do know a lot of the staff at NCBE, and I can guarantee you their psychometric staff will always be considering this issue of score comparability over time. How they will get to it, I don't know. I don't know if they know yet. It's going to be a challenge, I know, to the test developers to do it. So I guess that's a stay tuned. I can appreciate the commission's concern of having to make a decision that's, you know, maybe 5 years in the making if you do need to rely on the national conference. I can tell you from a psychometric standpoint, they have a quality staff. There may be issues with the content and the way they implement it, but I do know psychometrically, I don't have much of a doubt that they will come up with a quality examination.
Thank you. I'm not able to see everybody. I don't want to miss anybody, but in the order that I have, it's Jackie, Jeremy, Neil, Donna, and I think maybe Judge Reeser, but I can't really see it. Okay, yes, thank you.
Thank you, Justice. And thank you, Roger. Just a quick question about whether open book versus memorization is a pro, con, or neutral when it comes to the work that you do.
Well, given some of the premises and methodologies that I just talked about, I would not want to hypothesize whether or not an open book versus closed book would have a significant impact on the scores. That would be something that I would want to put to a test. It would be relatively easy to design an experiment that would do that. I would want to relook at, maybe at the same time, I'd want to look at time effects as well. And at the end of the day, let the evidence speak for the efficacy. Personally, everything that I've learned as a psychometrician working in the law is the validity of a closed book test is clearly something that I would question. You don't work in that kind of environment. You do need to have a certain foundation of knowledge. I don't know how much that is, how much you need to have at the top of mind or whatever, but my guess would be people would still need to acquire the knowledge, have a fundamental, or at a minimum, which might be even a better skill to have, is know how to find that information quickly. You know, clearly that's, you're working in a high pressure environment, you don't have everything at your disposal. The skills of quick research and analysis is one. Obviously, I think your CAPS identified that as a skill as well. So I guess if it was up to me, I would want to evaluate that.
Thank you, Jeremy.
Thank you, Justice. I just had to turn off the mute really quick. So a quick question for you, Roger. Thanks again for your wonderful presentation. So I remember when I was studying for the exam, how the MBEs and the written part somewhat complemented each other. So like when I would study for the MBE, for example, and I would get questions right or wrong, that would then be reflected in my essays. And I would remember a certain point and say, oh, that's a, you know, an issue spot or a piece of law that I didn't realize. So what are your thoughts on that, on maybe how the written exam and how the MBEs complement each other?
Well, I know statistically, and I've worked with, you know, over 25 states over the years. The way a psychometrician looks at that is not only by similarity of content, but also by kind of what's the relative standings of people who take the MBE and who score and how they score on the essay. And that correlation runs between out of a scale of -1 to +1, generally runs about 0.6, which is high, but it's not perfect. So it doesn't surprise me that the more overlap in content there is between the two methods, is the more those two types of instrumentation would tend to relate to each other. And again, some people learn, they have different methods of learning. They do better on the a multi-state than on a written test. But overall, and that's how we kind of have to look at the world, there is a significant overlap. And what that suggests to me as a psychometrician is that the core knowledge base that the tests are assessing tend to have a very large commonality. And it's at the fringes where the methods start having an effect. And that's your tough job then to determine whether or not you want to be modifying the methods that are out there. And again, balancing these four cornerstones to do it. I think written tests are out there for a reason. And the exam has stayed the same for a reason, because it's time consuming and costly to make those changes and to prove that the changes that you've made are effective ones. And in the absence of kind of a strict experimentation, I don't know, Judge, what your plans are when you implement in New York. I worked on your October exams with your director, so I have a sense of kind of what things were going on. I don't have a sense of how you'll be evaluating your changes to the exam once they're in place. But I think whatever the commission does, it should be considering how it will be evaluating the efficacy of your changes relative to what you're looking at now.
Thank you. Neil?
Thanks, Justice Guerrero. Hi, Roger.
How you doing, Neil?
Good, good. How are you? Well, we know how you're doing. We're grilling you with questions for the last minute. So here's another question. Assuming California keeps some sort of multiple choice component, whether it's through the NCBE or through California drafted questions, what effect would it have on the exam if, say, the written portion of the exam was essentially only various performance tests? How would that affect validity, reliability, and fairness?
Well, the issue of validity obviously would be a subjective one. You'd have to go through an exercise of determining the content that was being dropped. So that would be again, I think bringing subject matter experts to the table to say, I'm no longer assessing that content. Reliability, that could actually be estimated. I don't know what that is offhand, but again, with the last October, we did go through the exercise of trying to determine the absence of an MBE, what would the reliability be? There are psychometric methods to look at that and make come up with a quantification of the impact. It's nothing I could do off the top of my head, but it could be done. Say, for example, if you wanted to put 3 performance tasks and no essays, or you wanted to have 2 essays and 5 performance tasks, that can be modeled in advance of making changes. Again, that all assumes that everything else is held constant, meaning you're using an MBE, you're using similar essay questions as you've had in the past, and you're using similar performance tasks. That could be estimated.
Thanks, Roger.
Thank you, Neil. Donna?
Thank you, Justice Guerrero. First, I want to respond to something that Susan said, just because I think it is fundamental to one of the decisions that ultimately this commission is going to be making. And then that'll lead into my question. And so, Susan, that was an issue of whether or not there was going to be an MBE or something like it that would be a standalone when NCBE develops the next gen exam. So something that we could use that Californians and other states could take if they don't adopt the next gen exam fully. I think Justice Shankman was right when he was describing the exam as sort of intended as a fully integrated exam. The way I describe it is, what I see is, there will be a series of descriptions several paragraph descriptions of a scenario. And for each scenario, there may be some multiple choice questions. There could be some short essay questions, short answer questions, or some longer answer questions. But all of those pieces would be integrated. I know the NCBE has not, is sort of mulling over the idea of could they continue producing an MBE for some number of years for states that still want to rely on using the MBE and only the MBE. Is there some module of the next gen UBE that could be extracted? We don't have answers to those questions. And that's I think among some of the challenges that we don't know if we will have an MBE or something that can be extracted to ensure the score comparability. Which leads to my question on score comparability, Roger. So it's not just the act of creating our own multiple choice questions that would allow us to ensure that score comparability or level of difficulty from year to year. Presumably there would need to be some level of, I don't know, is it sort of replicating some percentage of questions every year to see how they test as compared to the other questions? Is it extensive pre-testing? Sort of what is it that needs to be done with our own multiple choice questions that would allow us to have confidence in the comparability from year to year?
This is what you'd have to do. You basically would have to take on all of the activities that NCBE currently does as a testing agency. You would have to replicate items. That's why the question is, how many items would you need on the test? Part of the process of equating, which is what NCBE does, is they replicate 25 items every examination. They're experimenting with 25. I believe they put in 20 reusable or 20 items that are common across exams, and they're using those common items to ensure that comparability through what's called IRT equating, which is rather complex process. But they are going through that every administration. They're also field testing items in the exam. They're field testing 25 items. So basically, Donna, what you would have to do is you'd have to implement or contract out, or however you would make that happen. You would have to become a small testing agency. You're kind of walking on the edges of that now by having your written portions developed. And you've got a small infrastructure, but as you start moving into kind of the multiple choice, or for that matter, maybe other methodologies, you have to think about all of those, all of these challenges here that I've checked off. IT support. You've got issues about test security. You're putting out training manuals. A lot of the things that NCBE is currently doing now for you as a qualified testing agency. There are testing agencies out there that this is their livelihood as well. They're in business to create tests, and they're good at it. They have efficiencies because of their infrastructure. But again, it's a challenge for you to determine how far down the pathway do you want to go within your organization. Do you want to farm it out? Do you want to eliminate it completely? I'm not in any position to tell you A versus B, but I just wanted to lay this out here for you so that as you consider it, all of these things are out in front of you for your consideration.
Okay, we have two quick questions. I know we're over time, so I'm hoping to get through these two questions from Judge Reeser and then Natalie. Thank you.
So Roger, thank you for the information. It's very helpful. I was going to ask Jackie's question, but I listened very closely to your response, and so I just have a brief follow-up question. As you aptly noted, taking this omnibus, multidisciplinary, closed book exam is the antithesis of what lawyers do for a living, right?
Right.
And so if we had an open book exam, which would better replicate what people actually do, which is the job, you indicated, you told Jackie that it would be fairly easy to examine that and create the analytics associated with comparison between open book and closed book. So when you said fairly easy, the question came up, does that mean that's something you could do within 60 or 90 days, or is that more of a long-term analysis?
No, this gets closer to the assessment center model, special sessions model. When I say fairly easy, it's easy to design. to implement is another issue. Finding test takers to go out and try it. Arranging all of the procedures to ensure that a random group gets the test version A and another group gets version B and version C. The advantages of doing that is you have a definitive answer. You're not basing it on somebody's judgment to say, oh, 5 more minutes on it is not going to help or will help a lot. You just let the data speak for itself. What happened back in the 80s is that there were so many questions that were out on the table before the bar decided to make any changes. They wanted to have a handle on answers to these questions so they wouldn't be making long-term changes based on supposition and assumptions and hypothesis without any evidence. So that's what I mean by easy. The analysis is easy. Getting the data in place and getting it the right way is a challenge.
Thank you.
Thank you, Natalie.
Quick follow-up, Roger. So when you said it would have to have a minimum of 100 questions, that's 100 questions that are scored. So if we wanted to add any test questions, it'd have to be above the 100.
Yeah, I mean, there's a lot of work that would go into a final decision about what the 100 items would be. Understand that one of the reasons why NCBE has used 200 items is while they don't report scores in subtest areas, they've been pressured to do that. They're concerned about the reliability of the subtest. Once you get down to 100 items, you start asking questions about, do I have sufficient content coverage? Will I be able to pilot test enough items to keep this thing fresh on a constant basis? The challenge of having an open versus closed book could have an implication. How much, people are spending more time flipping through pages to find answers. Is that a different skill that's being measured? So it's a little premature in my mind to kind of think about how many questions you would have. I think there's a lot of issues ahead of that in the queue that you need to consider. I think once you arrive at the idea, we want a multiple choice or we don't, then you can start considering how much time do I want to allocate to it. If I got a more innovative way to do this, to provide this content, maybe I want to focus on that and not put as much weight. And maybe you use a multiple choice kind of test just basically to anchor your exam.
Thank you, Roger. I think we could spend all day talking to you. This has been very helpful, but I'm going to have to move on to the
I'm
next
sorry I took a few
presentation.
extra minutes too.
No,
Judge.
don't. It's very helpful. I think we needed to hear all of this. We had a lot of questions for you, so we appreciate it very much.
Thank you.
Thank you. I'm going to hand it over now to Donna and Amy to talk about pros and cons of California specific approach versus adopting the UBE.
Thank you, Justice Guerrero. I am Roger, if you can stop sharing your screen, I will share mine. Okay. Okay, So as we said earlier in today's meeting, one of the foundational decisions that this commission will need to make, if we are to continue utilizing a licensing exam for determining minimum competence and the path to admission, one of those foundational decisions is whether it should be a California developed exam or whether we should adopt the next gen UBE that the National Conference of Bar Examiners is developing. After the presentations at the July 6th meeting, and the presentations for today, so far today, we wanted to summarize for you what we've gleaned so far as some of the pros and cons that may impact that choice that the commission is ultimately, not today, but ultimately going to be asked to make. After we go through some of these pros and cons, we've also identified some issues that we believe that at this point we believe the commission will feel that they need to learn more about in order to help them make that important decision, and Amy will lead us through that part of the discussion. So as you can see, I certainly don't need to go through all of the bullets on all of these, but just sort of taking a look at the pros and cons of going forward with adopting the next generation uniform bar exam. As Roger mentioned, the NCBE has access to professional test developers. They're a test development organization, and that certainly brings benefits to it. Portability is an issue that certainly is of concern. And we heard New York talk some about portability. And there is, if we were to adopt the next generation UBE, there would certainly be the potential for some portability with the exam scores. So people who go to California law schools, test in California, get a certain score on the uniform bar exam would be able to be admitted to other states. We say potential for some portability because there's also the question that we have today about Californians from other than ABA accredited law schools in California, and whether states would allow admission based on a UBE score from California law students that went to a California accredited law school or a registered law school. And it's certainly something that we always look out for, is ensuring that there is that students who graduate from all of California law schools have the same benefits.
As well as law office study. Sorry.
And law office study, I apologize. Yes, all of the different opportunities that we offer here in California for admission to the practice of law. Using National Center for Bar Examiners, they also would develop a scoring rubric as part of the grading process to ensure consistency in the scoring of the exams. Also a benefit. We develop scoring rubrics as part of our grading, certainly, but again, as professional test developers, we would have the advantages of the scoring rubrics that they develop. There is the potential for greater pre-testing of questions, going back to the issue that we were talking about just before with Roger, and the need to do some significant pre-testing of questions, especially if you're looking for something that is going to ensure the comparability of the difficulty in the scoring of the exams from year to year. We would suspect that that NCBE would have a greater likelihood of being able to do more widespread pre-testing of questions. On the administrative side, if in fact we were able to use test centers, which is one of the currently under consideration by the National Conference of Bar Examiners, use test centers, it would certainly eliminate the complexity of contracting for the different hotel sites, and us proctoring and arranging for proctors at 16 different sites across California, which we currently do. It would create uniformity, obviously, in the testing from state to state, and which could also create some greater belief in the reliability of the exam. And also, as we talked about at the July 6th meeting, the practice analysis that the National Conference of Bar Examiners conducted concluded that the knowledge, skills, and abilities that are needed, that they are using to formulate the next gen bar exam are comparable to the knowledge, skills, and abilities that we had identified through California's practice analysis. And so it's not like we would be going from apples to oranges, where we determined we really need to know these 27 things, and NCBE determined you need to know 27 completely different things. There really is quite a level of overlap between the knowledge, skills, and abilities that we identified and the national conference identified. On the con side, reasons that could argue against going with the next gen UBE, there would be a complete dependence on the National Conference of Bar Examiners. They would be the decision makers. They would be, I think you can now see my meeting announcements. They would be, the decision makers. They would have 100% control, obviously, over the content of the exam, and potentially administrative issues that come up, say, for example, with the pandemic, and the decision of whether or not we can go remote. We potentially wouldn't have a lot of authority to make a decision about that on our own. That would be a decision that would likely be made after considerable input from all of the jurisdictions I am certain of, based on NCBE's past experience. But ultimately, it would be a decision that they would make, and we wouldn't have our own authority to make decisions like that. As we've talked, right, this is a relatively unknown format. It is in the conceptual stage. National Conference has put out that schedule of when they would be identifying, being able to provide samples and modules for people to look at. But right now we don't have something to look at and say, yes, this is exactly the kind of exam we want. We would be going largely on faith. And then sort of the next two bullets, and we'll talk more about this when we get to the more information that we need slide. But what we know is that as they're currently thinking about it, if we were to go with the next gen UBE, that would eliminate the possibility of a remote exam or an open book exam. And if we wanted to preserve the opportunity to do that, then we likely would not have that opportunity if we went with the next gen exam. Also, they are still working on what the options are for people who can't test on a computer. I have full faith that the National Conference will come up with appropriate methods to accommodate those with disabilities that impair their ability to use a computer. But there are also those who have issues that are not issues with using a computer that are unrelated to any disability. Current conversations that we've been having seem to suggest that in such instances, there likely would not be the ability to test by hand with pen and paper. And also, right, as New York talked about, there would be no California specific content. If we did decide that we wanted California specific content and liked the format and structure and the other pros that are offered by going to the next gen exam, then we would need to create our own California content in addition. Pros and cons of going to the California exam, starting here with the opposite of what we talked about with the UBE, preserving our options for remote testing, for open book testing, preserving our control over the examination process. Also, right, if we were to develop our own exam, we would have complete freedom to create, to examine all of the innovative approaches that are out there to exam delivery, looking at computer-based scenarios, simulations, clinical, the CSTs that Roger was talking about, looking at things in terms of the frequency of the exam. Will we just be delivering it in in February and July of every year, or could it be more often? All of those kinds of possibilities would not be within our within our consideration if we went with a California only exam. And also it has the benefit of testing California law. And although there was significant overlap with the knowledge, skills, and abilities, there was not 100% precise overlap. And so going with a California exam would allow for that more precise overlap. Finally, looking at what are some of the cons, and again, this is all select. This is not a entirely comprehensive list. It's sort of what we've gleaned so far. But some of the negatives of going with a California only exam is, as we just discussed with Roger Bolus, the need to ensure the stability and consistency across exams without an MBE, which could be, I'm sorry, and that, right? So we need to ensure that there's stability in the comparability in the scores from year to year, that we can adjust for the difficulty in questions, or ensure that questions are not more difficult from one year to the next. So that is something that we would have to pay considerable attention to if we were to develop our own exam. We would also likely need to develop and maintain a sizable bank of questions. We obviously need to determine how many questions are needed from year to year. If we were to go with multiple choice, performance test, essay, some combination thereof, all of those. But if we were relying solely on California developed material, we believe we would need to develop a sizable bank of items that could be used, and with multiple choice reused from administration to administration. And then sort of looking right at looking at the other cornerstones of licensure exams, we would need to also, in addition to reliability that we've talked about, we would need to ensure the validity of the exam. These are all, as Roger said, like the importance of these cornerstones cannot be overstated. And so it would, so that was something that we would certainly need to ensure. And, that would give confidence in the exam and be important for anybody that we choose that gets admitted to the state bar, to ensure that there is confidence that the exam was valid, that it measured what it was intended to measure, and that we did in fact admit to the California bar all those who are minimally competent, and not those who are not minimally competent, but all those who are minimally competent. A negative to a California only exam is we can be fairly certain that there would be no portability. You would not be able to take that exam score and plop that into another state and suddenly be licensed in that other state. And then there is the administrative part of exam development and grading, which would be on California, and we would have to develop all of the tools and the mechanisms in order to develop the exam questions, do the grading, and all of the components with that. Things that would be that if we went with the next gen exam, NCBE would be doing. I talk a big game about sort of thinking about what are all the things that the staff and admissions could be doing if we weren't doing the administration of the bar exam, and we're relying on someone else. I don't have an answer to that question. It's just something that I like to think about. But it is certainly a considerable effort and a big part of what our staff spend our time doing. And if there was somebody else who was handling some of those responsibilities, that would be a benefit to California. This is only, as I said, a select list, but before moving on to what are the things that we need to learn more about, which Amy will talk through, I just wanted to pose to you all a question of, are there other pros and cons that you think are critical that we capture at this juncture? I see David, you have your hand up.
No, I have a question, but it's not in response to what you just asked. I was just getting myself in line.
Okay.
Thanks.
Well, seeing no other hands, then Amy, and this may inform the questions and other comments that you have. Amy, if you could lead us through what we think is some additional research that is required before the commission can answer the question of California developed exam or next gen UBE.
Great, thank you, Donna. So as Donna's highlighted, we've gone through this pros and cons of each of these paths, whether it's sticking to a California exam or adopting the NCBE's UBE in its new format. And so we presented information on that can shed light on that question, but these are areas that perhaps require further explanation. So the first, with an eye toward access, research on the disparate impact of on race, gender, and ethnicity of question types could provide more information that are a factor in making this determination, along with cost implications. And also, and what I mean by that is, are there, we can evaluate are there types of exams that would amount to reduced fees for applicants and that are cheaper to undertake. Also, in terms of fairness and equity, looking at whether open book and closed book has an impact on fairness and equity. Also looking at the remote versus on-site modalities and what impact that has on fairness and equity. And we see this, for example, played out a little bit in when we had hosted the on-site online exams, the past two bar exams, as well as our baby bar, where we've had to provide on-site arrangements for any applicants that were having a tough time creating a testing environment at home. So it'd be good to look at the research that exists that would address some of that. In terms of innovative methods of exam delivery, so I'm looking at what exists for other high stakes licensure examinations that are innovative. This is both in the delivery as well as the question development. And so we bring these to the commission as ideas of areas that we can further explore, but also to open it up and seek your input. Are there other areas that we need to research that would help formulate, ideas on the path that we could take? And we have a lot of hands up. So David, I'm not sure if you're ready to either ask your question or make a comment.
Yes, it's really more of a comment, and it has to do with the column on the next gen UBE, the cons, and Donna talked about that, and the bullet says that it would eliminate the possibility of open book exam, and I think there's some nuance there that might be important to think about. Much like the current multi-state performance test, where there is a closed universe of materials provided to each examinee so that each examinee has exactly the same materials to work with. My understanding is that the next gen UBE is going to have even more of those kinds of closed universe questions where each examinee is provided exactly the same materials. So I'm not sure that to say it would eliminate open book is entirely correct. It would perhaps eliminate sort of an uncontrolled open book where various examinees might have access to materials that others didn't. Kind of an arms race for materials where you might create unfairness and inequities there. But it would in fact create sort of a quasi open book situation, which would be fair to everybody because the same materials we provided. So I just make that observation, as I say, just to put a little nuance on that open books point.
Yeah, I really appreciate that, David, because that certainly matches my understanding that there would be a lot less rote memorization that is required by the new structure that the NCBE is envisioning with the next gen bar exam, and that, yeah, there might be mini libraries, there might be, and just the structure of the question is different. And then in terms of what you were getting at with the issue of the fairness and equity, because who has access to what resources, that is certainly why we put that on the further research is required, because we can't tell you right now that open book is fair, or isn't. We don't know. We know that there are studies out there. We know that there are psychometricians who've looked at this question, and so though some people may have a leaning in favor of or against open book, it's certainly a question that we need an answer to, that staff needs to provide the commission an answer to, before I think the commission would be ready to make a decision of, do we even want to have the possibility of doing that?
Thanks very much.
Emily?
Thanks very much. This is super helpful. I guess my request, or I don't know if it's researchable, but certainly one option that I think is maybe under consideration, maybe not, is to have two pathways to licensure, one being an exam and the other being an alternative method. And if that is the case, and again, I don't know, but one option might be to adopt the NCBE as the method of testing, because it provides reciprocity and in fact, having a organization that is dedicated to testing that would be handling that. Again, it doesn't have to be NCBE, maybe it's another testing service, but I think the NCBE would give the reciprocity that I know a lot of our law students and then attorneys in other states have been requesting, and it kind of moves us along in working with other states. It's not necessarily part of our guiding principles necessarily, but I think it does offer something, and it obviously would offer some sort of exam. Again, I'm not saying it has to be that, but if that's one path, is reciprocity something we should be shooting for? So I guess that would be the research that I would want to know is, do we care enough about reciprocity? Are we getting that many requests, to be able to have that? Is that something that our law schools, law students, attorneys from other states would like to see? And if we had a two-track pathway to licensure, one being, so if you graduated from a law school in California, you could do either. You could do the NCBE or you could do whatever this alternative method is. But maybe if you graduated from a school outside of California, you could only do the testing thing. I don't know. But I'm just saying, like, that might offer a way for the state bar to get out of the testing business and into more focused on this alternative track, if it wanted to. So anyway, I guess that's what I would say would be helpful, is maybe it's just thinking about requests for reciprocity from other outside attorneys. And then is there a dual track with, if we have testing, what would we need the alternative to be? Thanks.
Thanks, Emily. Judge Rosie?
I think actually what I have to say is very similar to what Emily just said, and that is that I had a question about this portability argument, because I heard Justice Shankman say that in New York, that was one of the reasons why they went to the UBE, and then they found out afterwards that actually that wasn't as important to law students as they thought it was. So I guess I'm wondering if we have data on how many California law students are actually wanting to leave California to practice. We know, of course, from the accredited and registered schools that most of those students are staying in California, not all. But I'm wondering if we can do some research and really get some data on whether this matters to anyone other than perhaps us.
Yeah, and that is certainly research that we can do. We have a large database of most of the law students in California, and we can survey them. We can ask the deans of the law schools to survey there are law students, whichever way would be sort of the most effective way to do it. We can coordinate with the deans and figure that out. So that could certainly be on the research list. Tracy.
So to echo other comments, I agree. I think that really before considering the UBE, there needs to be a determination of whether or not reciprocity is important. Otherwise, we could be wasting really valuable time when it may not be an issue. If the data does come back and indicate that reciprocity is important, then I think what's important to do is a formal review or audit of the UBE. And I'm going to reference a resource brief from the Council of Licensure Enforcement and Regulation. It's what we model our audits on national exams. So before we even recommend to a board that they consider utilizing a national exam, we go through a very thorough audit that looks at everything to support the validity, the reliability, the fairness, how the test is administered. We need them to provide us the evidence that it's defensible and that it's reasonable. So I'll share this, I'll scan it and share it because it looks at every aspect that you need to, that was on the prior graph of what goes into a testing program. And I think then when you have that information, then you can move forward with whether or not it's going to fit. I think it's hard right now because they're in development, so there's a lot of information missing that we have no idea whether or not it's going to work. So that's just my 2 cents on that. Thank you.
Thank you. I realize, Justice Guerrero, I've stepped on your role of calling.
Oh, that's okay. You're doing a great job.
Okay.
It looks like we have 2 more. Thank you.
I see 3, Karen, and then Neil, and then Charles.
Yeah, and I'll be very quick. So just on the portability question, I guess one other just aspect of that, I'd be curious to know over the, again, lifespan of a career, if this is relevant, where California, licensed lawyers move, or alternatively, where are lawyers coming from? Because that may also indicate where we could address maybe portability and reciprocity through other sorts of agreements. So basically the import-export of lawyers, not necessarily law students who may not know that they're going to be relocating. So that on that point, the other, I just want to make an observation on the list of pros and cons for the California solution. I appreciated the innovation opportunity where we talk about the opportunity to approach different methods of testing and different targets for testing. I think we have to just add to that list questions around scoring and using technology to do the scoring, because that's going to very quickly become an issue as much as the method and form and factor. So I just want to not lose that dimension of the innovation.
Thank you. Yeah, and one of the things that this really sort of allows us to continue to focus on is how do test takers of today test, right? And who are the majority of our test takers, right? Are we past the millennial generation as our test takers now? Or are we still in that? But how do they test? How they do things is very different than how I did things. I don't want to tell you when I took the bar exam. It was very long ago. But having the sort of the developing the exam on our own allows us to continue at our own pace to update the methods based on the way people learn today.
Yeah, and I love the idea of the optionality. I mean, maybe figuring out what scope of choice we can put into the hands, maybe even of test takers around what they're comfortable with. I don't know, but that would require our own format.
Neil.
Okay, yeah. So just one quick thing. One way in terms of the reciprocity issue and the interest of folks in that, you could survey not just only law students, but you also have every year, twice a year, a group of folks that register for the exam. You could survey them directly. But my other question is this, and sort of along the lines of fairness and equity issues. So I know, at least here in California, for every single administration of the bar exam, you folks release all the data transparently about race and ethnicity in terms of pass rates. And I'm asking this question more out of ignorance. I don't know, does the NCBE do that? And for their UBEs, and are there plans to do that if they don't on a regular basis? Just a point of question there.
I would expect that would be state driven, because each state is still determining, right, what its passing score is. So I don't know that. So I don't know that they. I don't know that NCBE maintains the information on the test takers. So I would expect that would be up to individual states to do that.
Okay.
It's certainly not something that I personally have looked at. I would doubt that most are as that most states have data as fulsome as ours.
Okay.
And Charles.
Oh, thank you. But Ms. Silverman essentially posed the question that I was going to ask about the import-export over the course of careers. So I'll just lower my hand, so to speak.
Great. We've gotten two more hands. Justice Guerrero, do we have time?
Yeah, if we could go ahead. Thank you.
Alex Chan.
Thank you. One of the issues that I would like to sort of explore, and this is based on what Judge Scheckman said earlier, which is, we need to study the state and local law and understand how they play a role in the work of young lawyers. And I think one of the slides that he had earlier was that, and this is based on a survey that they conducted, which says basically 50% of the people surveyed worked only with the state and local law, and then the other 50% with a mix of federal, state, and local law. And I think on the issue of portability and reciprocity, we really need to understand of the people that we will survey, how often and to what extent there would maybe impact on their work, and also how much and to what extent that they would use state and local law during their practices. So I think this is something that sort of go hand in hand with the survey if we decide to go down that path to survey the students or applicants.
So Alex, were you suggesting this sort of both ways? How much do entry-level lawyers primarily in California primarily work in state and local law, as well as if we were to offer reciprocity to those from other states, how much do they, is it both ways?
Right. Yeah, essentially we need to understand whether they play a prominent role in the work of young lawyers or applicants.
Jim.
Thanks. My question really came up when Tracy Montez was talking earlier, and someone asked about alternatives to licensure tests that were in use in California. I think looking nationally at what alternatives to licensure tests different professions might be using would be really helpful to understand more about the design of those processes and how they address the core questions of validity and reliability and fairness that so many of us have been talking about in the meetings so far, how they address them, and then what the results of those analyses are, how well they end up actually addressing the validity and reliability and practicality questions that pertain. Anyway, just my thought.
Is that more a question, Jim, not of California developed versus UBE, but rather a question of, is there a test, or is there something other than a test?
Well, I think if the UBE is not headed in the direction of an alternative to a licensure test, so it would be California that would be considering that. And it strikes me that if you're thinking about a California exam, then this alternative has to meet the same standards as the California test does. Maybe this is not the right time to pose the question, but I think there certainly, I've seen a lot of interest among the public comments as well as the conversations in the commission about alternatives to the licensure tests. So we should just take a look, I think, at what they are and how well they work.
Yeah, and I think this is, the reason I asked the question is I think this is for the afternoon part, or we're in the afternoon, the rest of the of our agenda today, and what additional research we need on those test alternatives questions.
Perfect. I'll hold the question then. Thanks.
And Justice Guerrero, we've gotten 2 more hands.
I'm gonna, I think at this point we need to be sensitive, and I apologize to the speakers who are coming up next, but we've gone over their time. And this is something that we will get to, and I'll keep note of the 2 individuals who have questions. But I think we need to get on to the next agenda item. And so I'm going to present the next speakers, Dr. Howarth and Dr. Merritt, who will be speaking to us about alternatives to testing.
Thank you very much.
Thank you,
Justice. And we've arranged this for me to speak first, and then Joan will be speaking after me, and hopefully we'll have time for some questions. We're not going to speak for the full 45 minutes. I will begin by sharing my screen. That works. And then doing the slideshow. There we go. Well, first, thank you very much for inviting me. I've learned so much from the commission and the other speakers by listening, and I hope I can contribute in return something that will be helpful for you. I'm going to talk about how we define minimum competence, as well as about how that definition corresponds to the current bar exam and what it might mean for the future. Most of my comments are based on a 2-year national study that I conducted with Logan Cornett and the Institute for the Advancement of the American Legal System. Several other educators and lawyers, including your very own Natalie Rodriguez, worked with us on the project. The study is called Building a Better Bar, and it did produce findings that are similar to the ones generated by NCBE's Job Analysis Survey and your CAPA survey. I think that our study provides additional context for your findings and hopefully will enrich them. You can see our method listed briefly here. We used exclusively focus groups to complement the surveys that had already been done. We held 50 of those focus groups in 18 locations across the country. 8 were in California because you're a very big population. We talked to both new lawyers and supervisors of those lawyers. We had very well-defined and planned scripts for those focus groups. The groups were quite diverse demographically, as well as by job setting and practice area. And in the end, we had more than 1,200 pages of transcribed discussion that we analyzed for our conclusions. Before I share with you our definition of minimum competence, I want to review 6 findings that inform that definition. These are really about the context in which new lawyers use their knowledge and skills. Justice Schenkman has already discussed our first finding, which is the extent to which new lawyers use state and local law rather than federal law. And I'll add only this to keep my time short. New lawyers use laws from more than one state. We're at a time period now where every law type of practice, from family law to corporate finance, transcends state borders. So it's not so much that new lawyers need to know by heart the law of their home state. It's more important that they know general principles that are applicable in many areas, in many jurisdictions, as well as that they are quite nimble in finding the law of whatever jurisdiction applies to their case. Let me look now a little more closely at each of these other 5 factors. We found that a substantial majority of new lawyers engage directly with clients. These are just 2 quotes from the study, one from a new lawyer and one from a supervisor about the importance of that engagement. We learned from this that our definition of minimum competence and our licensing system really has to focus on this reality. New lawyers are not minimally competent today if they're not able to engage successfully with clients. We learned in the study that the lack of this competence does have serious consequences. The new lawyer I quote at the top here, for example, prepared estate documents for a client, but forgot to ask whether the client's spouse was a citizen. When the lawyer later learned that the spouse was not a citizen, the whole estate plan had to be redone. Now, the lawyer in this case understood the laws affecting estate planning, including the impact of non-citizenship, but either didn't know how to gather the information that he needed from the client, or maybe was unable to establish a sufficient level of trust for the client to share that information. We also found that a majority of the new lawyers in our focus groups handled client matters with little or no supervision. Even when they received supervision on work for paying clients, which was true at larger firms, those firms encouraged them to handle pro bono cases on their own. The second quote here reflects the discomfort that we heard from several new lawyers about this because they didn't feel that they were fully competent to handle cases on their own. So again, I think this reality has to inform our definition of minimum competence. New lawyers need to know more than just the legal principles. They have to know how to manage caseloads, negotiate with opposing counsel, and develop strategies for solving client problems. Again, we heard about ways in which a lack of these other competencies hurt clients. The first lawyer who I quote here told us that she almost let a statute of limitations run because she didn't have a good case management system, and her employer had not helped her understand what type of management system she should use. Once again, she knew the law, she knew the statute of limitations, but she lacked the skills that her client needed for competent service. This third fact is one that complements the first two. It was something of a surprise to me, but contrary to what we have often thought in both academia and the workplace, it is very hard for new lawyers to learn skills in the workplace. They actually learn new doctrine fairly readily when they need it, but they struggle to acquire essential skills. These quotes represent the experience of many new lawyers, and the supervisors we talked to confirm this reality. The supervisors told us, look, we don't have enough time to train people in basic skills. And what's more, we don't have any pedagogic expertise in doing it. You folks in the academy, you've developed in your clinical programs and so forth, the pedagogy. We just don't have that. Another factor that came through loud and clear in this study is that lawyers, new lawyers and supervisors told us quite emphatically that new lawyers should not be relying on memorized legal principles when they begin practice. There are many good reasons for this. The rules vary from state to state, so the memorized rule might be the wrong one for the lawyer's jurisdiction. The rules change over time. All of our memories are fallible, and legal rules are just frankly too complex to memorize effectively. As a result, our focus group members rejected practice from memory using very dramatic phrases like these. They also told us stories about wasting time or harming a client because they recalled a rule tested on the bar exam that just didn't apply in their state. Now, I want to make an important note here, which is that as these lawyers gained experience, they did begin to rely successfully on memory. I'm sure that many of you who, like me, have been in practice for more than 2 months do that. We rely on memory all the time. But that's because the knowledge gained from hands-on practice is quite different from rules that we memorize to pass an exam. The knowledge we gain from practice sticks with us and can be relied upon, but for new lawyers, that type of reliance on memory can be quite harmful. Instead, the lawyers in our focus groups distinguish between familiarity with general concepts, which they needed, and memorization of detailed rules, which was harmful. They explained that a new lawyer needs to be familiar with a large number of basic legal principles, and that familiarity allows them to identify issues in client matters. And then when you combine that familiarity with good research skills, the general principles, allow new lawyers to find the detailed rules that they need. Now, here's a concrete example of what I mean about the difference between a detailed rule and a general principle. The paragraph at the top includes several detailed rules about diversity, jurisdiction, and federal courts. The current bar exam expects candidates to memorize each of these rules, including ones that I've left out after the ellipsis. The paragraph on the bottom states a general principle. This is the type of principle that I think every lawyer should understand. It reflects a key understanding of the legal system rather than memorization of the specialized rules that apply in one set of courts, the federal courts. As I think you can imagine, knowledge of this general principle is much more useful than memorization of the detailed rule. that federal rule isn't going to help the lawyers who work in state courts, which is where most new lawyers and indeed most lawyers work. The general principle, though, will guide a lawyer practicing in any court, whether it's one of the 13 trial courts in New York or it's an appellate court in California. Notably, we discovered from talking to our focus group members that lawyers who focus on memorizing specific rules, like the ones in the first paragraph, sometimes fail to understand the more general principle. We had several employers who talked to us about this jurisdiction issue, and they complained that new lawyers could recite the rules about federal diversity jurisdiction, but just didn't realize that state courts also had their own rules of jurisdiction, and they didn't know how to find those limits. In other words, to prepare for the bar exam, the new lawyers had memorized very carefully the branches and twigs of one particular tree, but they were missing the forest that they really needed. And here's the final characteristic of entry-level practice drawn from our study. We've talked about speed and what the bar exam requires in terms of speeded answers. The new lawyers and supervisors told us that care and preparation matter much more than speed in entry-level practice. They told us that new lawyers are supposed to take more time than their more experienced colleagues. That's why we'll bill them at lower rates, the supervisors told us. It's really care and preparation that matter in the first year of practice, not speed. So with that quick overview of the contextual factors, let me show you our definition of minimum competence. We built this on those contextual factors as well as all of the other information in our focus groups and identified 12 interlocking competencies that we call building blocks. And to refer back to something that Karen Silverman mentioned earlier in the discussion, these blocks are intended to establish both minimum competence and to provide the foundation for career-long competence and development. I'm not going to have time, of course, to go through each of these building blocks. They are discussed in great detail in our full report with all the supporting comments from focus group members. But I think you already can see some overlap with your CAPA recommendations. So let me go ahead and show you that. The blocks that I've just highlighted in yellow here would contain the 8 legal topics that you have in the CAPA report, assuming that you also are thinking about general principles rather than memorization of detailed rules. And the 5 blocks that are highlighted in blue correspond to competencies that you identify in your report. The other 5 blocks that are not specifically highlighted are consistent with what CAPA found, although they don't appear explicitly in your recommendations for a variety of reasons we'll talk about in a minute. The important point, though, is that new lawyers need a foundation in each of these areas to be minimally competent. It really isn't enough to have some of these skills or knowledge, but not the others. So let's take a look now at how these building blocks compare to the current UBE. I can talk a little bit about the next gen in the question session if you want, but we don't really have the answers on that exam yet. So I'm starting with what we know on the UBE. That exam tests at most 5 of these building blocks, leaving out all of the ones that I've grayed out. And most of that assessment, frankly, comes through the performance test rather than through the multiple choice or even essay questions. So only a part of the exam, a fairly small part, is carrying most of the work, and it's still falling short in testing minimum competence. Equally worrisome, this exam has competencies that don't matter to entry-level practice, in particular, the memorization of detailed rules and the ability to answer questions rapidly. These 2 features account for the extensive time that candidates currently devote to preparing for the exam. I think it's hard to even imagine the extent of memorization that the current bar exam requires. I see it every year when I see my former students who've recently graduated walking around with these huge packs of note cards that they use as flip cards in order to test one principle after another. Just the 7 multiple choice subjects require memorizing more than 1,000 rules, separate, distinct rules, like the diversity ones that I've listed before. That is simply just not something our brains are good at. During the 2 months that the candidates spend preparing for the exam, they're not learning about those subjects. They actually have learned most of those subjects in law school. What they're doing is repeated drills, repeated memory drills that will anchor all of those detailed rules in memory. And they're learning test-taking techniques to answer questions rapidly. That's one of the reasons that if you test people who've already prepped for the bar exam on whether or not they can answer the questions fast enough, they often can, because they've done special prep courses that help them learn that speeded work. This isn't really productive preparation, the 2 months that people are spending, because once they get into practice, they're not going to rely upon those memorized rules, and they're not going to need that kind of rapid fire response to multiple choice and essay questions. They're probably going to forget what they memorized for the bar exam. This was actually demonstrated recently in a study that Stephen Foster, a professor in Oklahoma, conducted. He recruited 16 practicing lawyers to take a simulated MBE, the multiple choice part of the exam, without studying. They were licensed practicing lawyers who we assume were fully competent, but not a single one of them passed this exam. In fact, the best score was 52%, and most of the others were lagging far behind. In fact, there were a few that were at the 25% no better than chance level. I think what I've said so far suggests that to protect the public, we need a different type of licensing system, or we need to make some substantial tweaks in the current exam we have. And my colleague Joan Howarth will discuss that in a few minutes. I want, though, to take a final few minutes to talk briefly about a question that was raised earlier, and where I think I can give you some data. So on the question of racial ethnic differences, we've known for 50 years that the bar exam constrains our profession's diversity and inclusiveness, that it has a seriously disproportionate impact based on race. Neil had asked about whether data are available. You're right that very few states collected the data until a few years ago when the ABA started requiring law schools to collect it. So we now have this nationwide data just released from the ABA, from the most recent exam that data is available on. And what we see here, these are graduates of ABA accredited law schools because the ABA gathered them. I'm sorry, I don't have data on the California state schools. But what we see here is that candidates who self-identify as white are significantly more likely to pass than candidates who identify with any other racial or ethnic group. And this has been true for the entire 50-year history of our current bar exam. Research suggests that there are two reasons for this disparate impact. One is that this exam, unfortunately, has become a test of resources. As I explained before, given the nature of memorization required, the exam requires 2 months of intensive preparation, usually meaning that candidates have to go without any sort of paid employment. They also purchase expensive commercial courses, which give them these memory drills and exam taking techniques. They don't study for the bar exam by taking the practice exams that NCBE provides. It's the memory drills that these companies have developed that allow them to succeed. There was a recent study done by the Access Lex Institute that shows the extent to which bar passage is now tied to resources. These researchers resurveyed more than 13,000 JD graduates of ABA accredited law schools who had taken the UBE for the first time in New York State. They got a remarkable response rate for social science, a 40% response rate. Almost 5,500 people told them about their preparation and exam outcomes. The sophisticated analysis shows that the graduates who had greater financial resources were significantly more likely to pass. The graduates who purchased commercial bar courses were also significantly more likely to pass. Those who worked for pay, conversely, were significantly less likely to pass. And all of this is after controlling for LSAT scores, selectivity of law school, and many other factors. So it's not that the people with more resources also have higher LSAT scores. It's people who have the same level of LSAT scores, went to the same type of law schools, are much more likely to pass if they pay for these commercial courses and if they take off the full 2 months to study. The second reason, I just slipped a little ahead, there's obviously white candidates who fall into that category of not having financial resources and needing paid employment, but the candidates of color are much more likely to fall into those categories. So that is one reason we get this disparate effect. The other reason is what cognitive scientists call stereotype threat. There's hundreds of studies in both the laboratory and the real world that show that, contrary to what we think, our competence and performance levels are not constant. I'm not as competent speaking to you as I would be in a different setting. In particular, if we identify with a group that is stereotyped as performing poorly on a particular exam, taking that exam will generate a special type of anxiety, which is on top of the usual test-taking anxiety that we all suffer. This anxiety, it reduces performance, which then leads credence to the stereotype and creates a vicious cycle. And ironically, this effect is highest among high-achieving people, so especially the type of people who will take a bar exam. And given the right circumstances, anyone can suffer from stereotype threat. There's one famous study, in fact, in which two groups of white men with strong math aptitude took a difficult math exam. One group took the exam in a neutral environment that did not elicit any negative stereotypes, and on average, they got 53% of the items correct. Another group took the exam in an environment that suggested that Asian men are better than white men at math. And on average, that group got only 36%, which tended to support the stereotype. On the current bar exam, of course, this type of stereotype threat works against candidates of color, and it can spell the difference between passing and failing. So let me turn the floor over now to my colleague, Joan Howarth. I think she will leave time for questions to both of us at the end. Thank you so much.
Hello, as I get myself set up here, I just want to start by thanking you all for giving me the opportunity to talk with you. And also to thank you for the hard work that you're doing. Particularly to honor that hard work, I want to emphasize that the serious reexamination of the bar exam that you are making today is long overdue by showing the results of a prior California State Bar Commission from almost 50 years ago that was charged to investigate bias and determine if the bar exam is related to the practice of law. That commission's report explained that identifying minimal competence was so hard that they decided not to even try. They just didn't know how to do it. They said they did not attempt because they did not know how to do it. One of the commissioners said, hopefully one of these days, somebody will come up with an answer. So one of these days has turned into one of these decades, and here we are today. The hardest part of your work isn't the technicalities of reliability and scoring. The hardest part is increasing validity. And the other hard part is breaking out of our habits, which are so long-standing that we sometimes cannot see their shaky foundations. Bar exams really have become the defining ritual of our very cautious profession. In order to try to get to the foundations, I have identified 12 principles, the first 6 of which I'll talk with you about today. First of all, base every licensing requirement on evidence about minimal competence to practice law. We now have research on minimum competence to practice law, and we have the methods to accomplish this well. The long era of the comfort of tradition, of I know it when I see it, and the sufficiency of good faith should now be over. Secondly, eliminate unnecessary racial, ethnic, and gender disparities as if required by law. By using the adjective unnecessary, I do not mean to suggest that some disparities are necessary. I don't know whether any are necessary, but I'm making a modest but powerful claim. The legal profession should hold itself to the same standards that Title VII has imposed on employers who use employment tests with discriminatory impacts. Title VII made police departments throw out racially discriminatory English tests, and fire departments get rid of non-job related requirements that kept out women. Bar examiners have one legal immunity from Title VII, but that means that we, groups like this, have to be our own Title VII watchdogs, our own civil rights actors. If there are ways to protect the public with less discriminatory outcomes, We need to do it. Another important aspect of access is reducing the expense of becoming a lawyer. We have constructed a very expensive system, especially when compared to other countries. Access and equity in attorney licensing requires us to make the process less expensive in money and in time. 3 years of professional education should be sufficient to produce competent new lawyers without the billions of dollars our future lawyers are throwing at the bar prep industry. So I want to talk about 6 pathways to better licensing, starting with the first one, which is to license lawyers through clinical residencies, not written exams. We should be licensing no one who has not successfully practiced law under supervision, preferably in an academic clinical residency. We should be using student practice rules as a formal stage in licensing, not just as an enriching elective in law school. If public protection is really our touchstone, as it needs to be, how in the world are we licensing new attorneys who have never necessarily seen a lawyer with a client or even been in a law office? The answer, of course, is in the particular, perhaps peculiar history of legal education in the United States, in which distance from practice became a chief mark of prestige and quality. But new lawyers should not be unleashed on the public unless they have successfully practiced law under the watchful eye and license of an experienced attorney. The clinical residence should be the equivalent in credits of 1 semester, which is still a very small proportion of law school compared to other professional programs. The specifics of the clinical residency really should be similar to the ill-timed TFAR proposal of several years ago. This is more than simply learning from experience. It's learning how best to learn from experience. What about quality control and assessment? That we should be using 2 methods in those clinical residencies. First of all, rubrics, the supervisor training and affidavits. The supervisor should submit an affidavit certifying the candidate has demonstrated minimum competence to practice law by means of successful completion of specified lawyering tasks. Also, candidates should submit portfolios, redacted when necessary, which bar examiners can review to confirm minimal competence. For scale in California, that means a system of random spot checks. And we're going to hear more, you're going to hear more about Oregon and New Hampshire, which are very similar. Another pathway is to license lawyers through postgraduate supervised practice. Law school residencies are stronger, but postgraduate supervised practice is a necessary transitional pathway while we wait for law schools to catch up. Postgraduate supervised practice is not as good as a clinical residency in law school, but it can identify competent lawyers as well or better than a paper exam. An intriguing version of a postgraduate supervised practice is an idea from Professor Eileen Kaufman, the Lawyers Justice Corps, that combines better licensing with a focus on access to justice. And essentially, California would designate public service organizations serving underrepresented communities to hire recent graduates who would practice under supervision immediately rather than spending the first few months after graduation cramming for the bar exam. We also have to ask more of law schools. I've already spoken briefly about clinical residencies, but there are other aspects of coursework that reverse engineering from the problems that generate malpractice awards and attorney discipline suggests should be part of what a legal education includes. So we should have law office and practice management courses or training certificates. There should be required courses or training in client relations and negotiation. There should be a required professional formation course, preferably as a 1L, that would highlight the lawyer's role as a public citizen having special responsibility for the quality of justice. It's an aspect of competence that Debbie Merritt's IELTS study has identified and recommended coursework about. Another model of another potential educational model, which could be postgraduate or within law school is to look north to Canada, where 4 provinces have established a training program or educational program that they are now using instead of a bar exam, which is designed to give the new lawyers there the competencies of practicing law, rather than, as Debbie just talked about, spending their time developing their expertise at spitting out multiple choice answers in 1.8 minutes each. Another way to think about some of these pathways is to talk about or think about competence-based diploma licensure. So I would say every jurisdiction, including California, should think about diploma licensure with a clinical residency, which is the cheapest, quickest, easiest way to add an option for licensure without a bar exam. That does require some experience, a proven competence in supervised practice. The other way would be with diploma licensure with a structured curriculum and portfolios, which is essentially what the New Hampshire and Oregon systems are that you're going to hear about, I think. We also need to think about reforming written bar exams. The tests that we are used to, which, as I said, are kind of a defining ritual of our profession for many of us, we have to reorient bar exams to legal methods rather than specific legal knowledge. The tests have stayed the same for the most part, even as the profession has changed. We have test questions today that are actually very similar to the very first bar exam questions that were written over 100 years ago. The NCBE's next generation test is definitely going to be a better test than anything that we have now. I'm excited to see what they could come up with. On the other hand, we have significant questions and concerns related to what their test design is going to be. Those questions include issues about speededness, about standard setting, about flexibility to change with the profession, and perhaps primarily about memorization. We're just not very good at recall. Think of going shopping without your shopping list, right? Debbie Merritt talked about the 1,000+ rules. Many of us would have a hard time remembering the eggs on a list of 12 items for the grocery store if we didn't bring our list. That's not what the practice of law is really about. So NCBE versus California, when we're thinking about the bar exam big leagues right now, there are really only 2 teams. That's the NCBE in California. When it comes to innovation, transparency, values of equity and inclusion, and research quality even, I'll say the CAPA study was had a much better response rate than the practice study from the NCBE, more sophisticated methodology in a number of ways. California has outdone the NCBE. In attorney licensing, we are now in a deep hole related to both job relatedness and validity questions and about disparate impacts. We've known this for over 50 years. The NCBE has not been the testing organization that we need on either of those fronts. So I would say, California, I would urge you to try not to settle and try not to remove yourself from the leadership position that you already have taken in the development of bar exams and the development of licensing, better licensing. So the next gen test will be better, but I think performance tests would be best. The performance tests were a California invention. Back in 1980, when I took the bar, back when Roger Bolus and his colleagues were studying all of us with our choices of new testing methods. The best way to protect the public through a written exam is to move performance tests from the periphery to the center. Performance tests are a feasible, flexible, relatively inexpensive, even elegant licensing test of minimum competence to practice law. As competent lawyers, think about what kind of tests would fairly assess the crucial skills and foundational knowledge you use as an attorney. A performance test-based exam could be administered during a single post-graduation bar exam, which could happen immediately upon graduation, or it could be staged throughout the second half of a candidate's legal education. California, for example, could require successful passage of 5 performance tests, one of which could be at the 1L level, at least 2 at the 2L level, perhaps 2 at the 3L level. These performance tests could be offered several times a year at test centers. Being handed a legal task, a file with the factual and procedural context, and a library of authority is a much more job-related test than the multiple choice or essay questions we're using now. The charge to the psychometricians should be to design and develop a testing, scoring, training regimen to make a system of performance tests as reliable as we've been able to achieve based on the NBE. Psychometricians have had 50 years to become expert at perfecting reliability calculations based on the NBE. And really, Roger Bolis and the NCBE psychometricians are superstars at that particular methodology. So what I would suggest is that balance is required. We're superstars. We're excellent on reliability right now using the NBE. But where we're falling down significantly and seriously is on the validity side, the job relatedness side. So I would say it's time to start to bring the validity side higher and to bring the science of psychometrics to reliable scoring of exams that are much more closely related to law practice. We can still meet the goals that we need to meet related to reliability, fairness, validity, and efficiency. So thank you very much for your attention. And Debbie and I are now happy to take any questions.
Thank you both so much. That was very informative and we appreciate your time here today. I'm going to go ahead and call on commission members. So it looks like first we have Susan.
Thank you so much. This was very helpful. I wonder if I could ask one clarification. You indicated that clinical residencies were better in law school and preferred over a postgraduate supervised practice. I wonder if you could talk a little bit about why, because I think just intuitively we tend to think, well, after they graduate, they'll know more, and that would be the preferred model than the in law school model.
Sure, there are really 3 reasons. One is the quality of the supervision. Even, we all know this, right? Even wonderful mentors in practice are not necessarily in a position to give the time to the training and assessment, the educational functions that are important to maximize the educational opportunities of the first practice experience. Essentially, as a clinical professor, I can summarize, it doesn't do justice really, but I can summarize the clinical teaching method as 3 words: slow everything down, right? Because we're trying to instill habits of self-reflection and habits of strategy and habits of thoughtfulness. That's not as easily accomplished in a busy workplace for many, many reasons that we can all kind of understand. Another issue is the cost. As I've said at the outset, we have a very expensive pathway into our profession. Many other countries don't require as many years of education. I would say we do not do our new lawyers a service by making them find additional, extend the time of their education essentially beyond the end of their minimum 3-year postgraduate experience. I had a third one too now, and just flipped out. Oh, here it is. Equity. So we have problems of quality, we have problems of expense, and we have problems of equity. The equity issues are the reasons that jurisdictions around the world have in some circumstances pulled back from articling, pulled back from the apprenticeship programs that they have, because those opportunities are often based on pre-existing relationships. And that's a significant problem. It was a significant problem in South Africa. It's a significant problem in Canada. We want to have a system in which there's an even playing field to be able to have access. So even with those three problems, I still think that the quality of experience that can be learned in a postgraduate supervised practice is so much better than what is gained by our current testing methods, that it's better than the status quo.
Thank you. David?
Thank you. Just a couple of questions for Dean Hollis. And it goes back to a comment that Dr. Montez made this morning about how practicality needs to weigh into our consideration of alternatives. And whether we're talking about legal residencies or supervised practice or portfolio review, is it practical to think that those kinds of approaches can be used on a scale as large as California with the number of examinees that they have?
We haven't done this yet, but I guess I would say part of what I'm urging you to do is to at least start with what would be the best way to establish minimal competence, and then figure out how to accomplish that. So we know that, for example, I understand that California teachers have a portfolio system. The technology exists now for registries of portfolios that it just wouldn't have been possible even a very short time ago. For me, a large state like California, unlike, say, New Hampshire or perhaps Oregon or Nevada, where I am, would need to have a system of spot checks, of random spot checks, and which would be then followed up by further investigation with data collected related to any kinds of patterns that were found related to the quality of the supervision, the seriousness of the assessments.
Actually, if I could add something to that too. You've been talking about cost effectiveness, but thinking about it so far in terms of the cost to the state and the bar examiners. One also has to consider the cost effectiveness of the method to the tests to the candidates. And the current system, which requires this 2-month special intensive prep that is different from what the educational track, is really costly to the candidates. A very conservative estimate is that it costs each candidate at least $10,000. That's the foregone income at just minimum wage of $15 an hour, plus at least $4,000 for the commercial prep course. So in a state like California with about 13,000 candidates a year, you're talking about $130 million. I mean, there are huge resources there. I'd love to see the state offer the portfolio track and so forth at the same fee that it charges for the bar exam. But huge, this is not a cost-effective system for candidates currently, not by a long shot.
Well, assuming California were willing to foot the bill for these alternatives, is it at the scale of California, is it possible or practical to standardize those processes in a way that would ensure fairness, which Dean Holland has already sort of mentioned, but that would seem to me to be a challenge too.
I don't think any more so than it is for the current bar exam. The difference is that when you're talking about portfolios from practice or even performance tests, you're talking about work product that is more familiar to practicing lawyers. It's not judging minimum competence based on somebody having half an hour to write an essay. That's difficult to judge. So that I think that you could, and we actually have started conferring with some other psychometricians about how one could work on this type of assessment. I think that you would find that it would actually perhaps be easier to standardize. Joan, what do you think? I'm sorry, I jumped into your question.
No, that was for both of us, but of course I would agree with that. And I would also say that anytime you're going to try to do anything new, it's going to take a lot of work to get it right, to get it good enough at the beginning, and then better and better and better. That's going to be true of the next gen test for sure, because the really extraordinarily high quality reliability has been established based on extraordinary stability, right? We've had the MBE for 50 years. So what I would say is we know a lot about, we don't know enough yet about exactly how to standardize rubrics. We don't know enough yet about exactly what the elements should be that would go into a portfolio. But those are doable tasks the question is, are they worth doing?
Thank you.
I don't want to monopolize. I wanted to ask about how you're going to, what kind of reliability you think you can get with 5 performance tests, but gosh, that'll take us into a psychometric discussion, and everybody else ought to have a chance to ask a question. Thank you very much. I enjoyed the presentation.
Well, just to respond in a very, very kind of minor preliminary way, I'm working on a project now with LSAC that is involved with creating a national version of a post 1L performance test. And it's very challenging, of course, to work on reliability on that kind of a sophisticated instrument, which in that case, it's not just it's a formative assessment. It's designed to be part of the educational process. So we have, I think we got it down to 10, we have 10 domains or aspects that are being measured under 3 levels of success. And the psychometricians who are working on that project are really excited about the fact that it is, it's important, right? It's different than the reliability issues that we've already, we understand with the methods related to the multiple choice tests. But they also are convinced, as I think the psychometricians at NCBE are too, that there are ways to establish reliability beyond the MBE.
Thank you.
Thank you. Jackie, then Kristen, then Neil.
Yeah, and Debbie, this is for you. If we decide to do a California-based test, would you recommend we supplement the CAPA surveys with the type of focus groups you perform to gain more depth around the knowledge, skills, and abilities that are required within those that we identified in CAPA?
I would think that well, first let me say that if you did want to do that type of study, it wouldn't be terribly hard because we would be happy to share our templates with you. And so you wouldn't have to start from the beginning. I'm not sure that you would need to do so because we did not find any differences across states in the research that we did. And we did include 8 groups. There were 4 from Silicon Valley and 4 from Los Angeles. So we didn't happen to include any rural groups in California, but we had rural groups from other parts of the country. And we have a great diversity of practice areas and so forth. So I don't think that, I always welcome more research, although I'm not volunteering to do yours, but we could provide you the template. But I think that the context we found also shows that the areas that you've identified for basic principles make sense. I mean, one could add or subtract to those, but the point is that it's actually not important to know. I have an evidence book and I teach every darn rule of the federal rules of evidence, but it is not necessary to have those in your head on the first day that you practice. You need to know the general concepts. And I don't, and in fact, if you have them in your head, you'll get it wrong in either a California court or an Ohio court, because we vary from the federal rules in lots of ways. So I would say that you wouldn't need to, but of course, read my report and see whether or not it gives you enough information.
Thank you. Kristen?
Thank you, Justice Guerrero. And either professor can answer this, but I guess my question is, I'm intrigued by the idea of the clinical residencies, but especially to the extent that it eliminates the biases we see for students of color taking the bar exam. But I'm wondering if that then creates a tiered clinical residency system where certain students are getting certain mentors and other students might be getting other mentors with less experience. And if the other states that have done this, whether it's Oregon or I think you said New Hampshire, if they've seen that sort of inequity replicated in a clinical residency.
My guess is that if you offered a clinical residency as an option, which I think you had been talking about, so an alternative pathway, you could take the UBE or you could take the clinical residency, that there will be a sufficient number of students who will want to take the UBE because they're good test takers and because they want that portability, that there will be plenty of clinical opportunities for the students who want the clinical residency. The other thing I can say about a clinical residency, having been a clinical professor myself, I made this unusual move from what I call the pointy-headed side of the law school to the clinical side about 15 years ago, is that although it's very helpful to take a clinic in your preferred area. I teach both a criminal prosecution and a criminal defense clinic, and the students who want to be prosecutors or defense lawyers really want to take those clinics. I also get students who are going to big law corporate firms who learn from these clinics the kind of project management and client interviewing and strategic thinking that they apply to those other areas. So I think that even though, there might be some students who would be disappointed that they didn't get to take a clinic in their preferred area, but they would still benefit from all of those skills. So I don't see too much problem with a clinical hierarchy. You might, if you create the pathway, that will encourage law schools to create more clinics, which will give everybody more of those opportunities.
Thank you, Neil, and then Leah, and then we have to move on. I should take a quick break and then move on.
Thanks so much for discussing the issue of anxiety in taking exams. And for me personally, I can say it's not only anxiety in taking exams, but it's also anxiety in actually being a lawyer and trying to perform competently out there. But I wonder what your thoughts are about the productive mindset intervention study that the bar has been doing for the last 3 years or so for its exams, and how I believe it's called the bar exam strategies now, and how it seems to be looking as if that giving positive reinforcement to applicants, especially persons of color, seems to really increase performance in some instances by double-digit percentage points. Do you have any thoughts about those studies?
Yeah, it's a terrific study and a terrific intervention. There are ways to reduce stereotype threat, and that's an application that is working on it. Those ways are expensive too. And they haven't been done in many places. So I would encourage you to continue with those investigations, but also to be aware of the costs that are being imposed in terms of stereotype threat, and whether or not the best way to avoid that is really to change the context. If you either change the exam enough or have something that's not an exam, that's the way to really do away with that threat. But I'm really glad California has taken that seriously.
Thank you. Thank you, Neil and Leah.
I'm wondering if you've given thought to this question of a remotely administered exam, the online exam format, and the open book exam. If we were going to say have a California specific performance test type of exam, what your research tells you about those particular modalities, if anything.
My research hasn't related to those issues. Joan might be able to tell you more because she's on the Nevada Board of Bar Examiners and had to deal with the issue. I will say that with remote administration, the facial recognition problems just escalated the stereotype threat. I really think that there were significant problems, right? If you are a person of color and you can't get access to the exam because you are a person of color, and it takes you longer, that's just going to magnify that stereotype threat. So I think that was a real problem with the remote administration. Joan, other thoughts on that?
And my only other thought, it actually My thoughts do come from my experience in Nevada, and obviously I'm speaking only for myself, but I did become a bar examiner in Nevada just before we dealt with the chaos and confusion of the pandemic. And so I have participated in helping to draft and score now 3 performance tests in Nevada. Part of what's interesting about what we've done there is that it's another experiment. We've based them on actual statutes, actual laws, actual cases, real. They're not constructed in a laboratory for test taking. They're based on actual statutes in Nevada and actual cases. One of the reasons that we went with an open book exam in Nevada was to prevent some of the surveillance problems that we knew would be difficult for test takers and candidates. My overarching response to your question, which is such an important one, is that the technology now, we need to push the technology to be able to be better, because we should be able to keep making exam formats and exam delivery more and more accessible. Right now, another hidden, or maybe not so hidden if you're a candidate, expense is the fact that we only have 2 exams a year, and they have to wait for many, many months where they're on hold essentially in their professional lives. So pushing the technology as much as we can within the constraints of privacy issues and the facial recognition problems, which have been extraordinary, but pushing the technology to be able to make people take tests on a completely different schedule seems to me to be one of the big advances that we should be looking for in the next 5 to 10 years, whatever the underlying modality of the exam.
Thank you. And thank you for your questions. I really appreciate the presentations from both of you. They were very helpful to us, and both that and your written materials. We really appreciate it. At this point, we're over scheduled quite a bit, so I'd like to take our break, but limit it to 10 minutes if you could. And I understand if you can't get back sooner than that, but it's 3:12 and we'll plan on being back at 3:22. Thank you. Welcome back, everybody. Looks like we have people joining now. Thank you. We're going to now hear from Professor Brooks, who will speak to us as the director of the Daniel Webster Scholar Honors Program to talk about their alternative bar licensing program. Professor Brooks.
Thank you, and thanks everyone. And I look forward to sharing a little bit about our program and then answering some questions. I realize we're running late, so I will shorten my presentation a bit and allow you some time to ask more questions at the end. So I'm Courtney Brooks. I am a former California attorney and bar taker, moved to New Hampshire where I am a professor of law and the director of the Daniel Webster Scholar Honors Program. I'm going to share my screen here just to give you a few things to look at. So the Daniel Webster Scholar Honors Program is a curricular-based program. Students in the program so it's a curricular-based bar alternative program that you've heard discussed earlier today as one of the alternatives to bar licensing. We are in our 16th year of the program. We are going to graduate our 15th graduating class in May of 2022. And when I say it's a curricular-based program, I mean that students engage in 2 years of practice-based intensive coursework, which is largely simulation-focused. They also combine this with supervised legal practice in a clinical program, or what we call a legal residency, which is essentially an externship. And then upon successful completion of the coursework and approval by the bar examiners, and I'll talk about that more later, the students are admitted to practice the day before graduation. So New Hampshire has one law school, and that's us. So that is an important component to the discussion, I think, and how we got here. Here is our third graduating class of the Daniel Webster Scholars Program. So it's also a small cohort. We started in the pilot program of 13. This is a group of 20, and we are now capped at 24 by order of New Hampshire Supreme Court. How did we get here? It's an interesting story, and it started with the former Chief Justice of the New Hampshire Supreme Court, Linda Delanis. Justice Delanis had been a Superior Court trial judge for over 20 years and started observing that new graduates, and even not that new graduates, were not leaving law school ready to practice law. And she felt there had to be some other way to assess practice readiness and minimum competence for licensure. So what she did was she impaneled a group of the biggest stakeholders in the state: the Supreme Court, the law school, bar examiners, New Hampshire lawyers, the dean of the law school, the board of bar examiners, and other interested parties. And they spent 2 years coming up with a curriculum. The curriculum was largely based on the McCrate report issued by the ABA in 1992, which included fundamental lawyering skills and professional values. These have been updated, and there are much better or much more recent things that you could use as a backbone, but the McCrate was what the Supreme Court used because it was the best resource at the time. So the program works by students engaging, as I said, in intensive course study over the course of 2 years. So they take their normal first year curriculum, they apply at the end of their first year, and then in their second and third year, they take, over the course of the 2 years, they take 6 Daniel Webster Scholar specific courses, which are simulation based, 4 electives, which are any courses that other students can take, 6 credits of law clinic or externship. They must graduate with a minimum GPA of 3.0, and they are reviewed on a regular basis by bar examiners. So the Daniel Webster Scholar specific courses include the pretrial advocacy course, which is the first course the students take in the fall of their 2L year. a mini series which is on bar tested topics that the New Hampshire Supreme Court and other state stakeholders felt were necessary, that students knew about but didn't require extensive coursework on them. So for instance, we have insurance law in that, secure transactions, family law, choice of law, conflicts of law, and other topics. We have a dispute resolution and negotiation workshop in the second year. And the students then also do trial advocacy, which is a continuation of the pre-trial advocacy simulation from the first semester. And finally, in the third year, and this is something that I think law schools could incorporate very easily into their curriculum, we have an advanced problem solving and client counseling capstone. And during that course, students spend 15 weeks with simulated clients where they both counsel, they interview the clients and they counsel the clients on the legal problems. And then at the end of the semester, we bring in actors who serve as standardized clients who score the students on standardized criteria. In addition to the Webster Scholar specific courses, the students take all of the required curriculum at the law school. So administrative process, criminal procedure, professional responsibility. An upper level writing requirement is satisfied in the pretrial advocacy course. But then we also require, it's not a required course at UNH Law to take evidence. All of our students must take evidence, personal income tax, business associations, wills, trusts and estates. And like I said before, either a clinic or what we call a residency. That's an externship, a field placement. So what do the Webster Scholars do in the classes? So as I said before, it's basically simulation focus. So here in one of these photos, you see one of our simulations, which is depositions. So every single student in the course, in the program, both takes and defends a deposition during the course of the program. And every single student in the program also argues a case before a federal judge, argues a motion for summary judgment or an objection. But that's just some examples. So in the pretrial simulation class, the students meet with their client on day one and spend 15 weeks bringing the case from the initial client meeting up to motion for summary judgment stage. That includes the depositions, as I mentioned. Real judges play a huge role throughout these simulations. They have a trial in the second semester. Like I mentioned, client interviews with standardized clients, often played by actors throughout the 2 years. Multiple opportunities to interview witnesses and clients, negotiations, mediations, and simulated business transactions in our business transaction course. In addition to the coursework, the students also do supervised practice, as I mentioned. And one of the things I didn't talk about is that our students also get trained and certified in our DOVE Domestic Violence Pro Bono project here in New Hampshire and become DOVE certified attorneys. We spend 3 sessions having them learn the law and then simulating a domestic violence protective order hearing. And many students then go on to do that work regularly, either while still in law school or at graduation. And then, as I said before, they must do the clinics or an externship. Many do both, in fact. And I would say, by and large, the students exceed the minimum of 6 credits by a lot. The last I looked, it was an average of 10 credits, which is nearly a full semester's worth of work. So the biggest component of the program in terms of learning is the feedback the students get along the way. So the students get feedback, both written and oral, from the professors, their peers, judges, outside lawyers. We have court reporters who volunteer their time, who give real-time feedback to the students, create transcripts for the students' review, all pro bono. Like I said, the standardized clients and witnesses also provide feedback. The other key piece, which I'm sure you're all the most curious about, is we have bar examiner evaluations along the way. So students are each assigned a bar examiner. Each bar examiner has 5 to 6 students assigned to them. They review a portfolio of the students' work prepared at the end of every semester. So students include their written work and then videos of the simulations. They include their reflections, and they include whatever assessments that they get. This is reviewed by the bar examiners, and then they schedule a meeting and they give the students feedback. And this happens 3 semesters, at the end of the fall, after the end of the spring, in the fall of the 3rd year, and then the final review is done the week before graduation. The assessments are based on clear and detailed learning goals, which have been created into benchmarks, what we call benchmarks, which the students are given in advance of doing a project, and then they get an assessment with the benchmark at the end of each project and simulation. These benchmarks were created in collaboration with the group I discussed before, the California Supreme Court, the bar examiners, and the faculty. And the bar examiners then look at those assessments in each semester. And then the big piece at the end is that they are admitted the day before graduation. So the students are sworn in both at the New Hampshire Supreme Court and the United States District Court for the District of New Hampshire, if they so choose, the day before graduation. And many of them will begin working often on June 1st. So I'm going to stop sharing and just address some questions that came up with other presentations, and hopefully address some questions that some of you may have. So one of the things I heard discussed in previous sessions was about portability of the bar licensure. So it is not immediately portable. So students who are in the program are admitted to New Hampshire only, and they can't take that admission with them immediately. Some states, especially in northern New England, will allow them to waive in after 2 years, and then others will allow them to waive in after 5 years. So after 5 years, the students have a lot of flexibility, much more limited flexibility at the beginning. I would say probably, we haven't looked at this data for a while, but probably about half go ahead and take a bar anyway, and many of them take the NBE. The cost to the student is very minimal, and that is a great benefit of this. The students they pay the regular tuition, and then they pay the cost of the bar application, but they avoid the cost of bar preparation courses, and they can begin employment immediately. And increasingly, the students do begin employment immediately. In the initial years of the program, a lot of the employers were demanding that the students take a bar in another state, and that has gone away in the last 5 years. The other piece of it is that while we are managing the program largely on our end at the law school, we bear the biggest cost of it on our end. There is an oversight by the New Hampshire Supreme Court, and we have an oversight committee. The bar examiners are all on that committee, 2 members of the New Hampshire Supreme Court, and we are in constant discussion with them along the way. The bar examiners are paid a small honorarium, but my understanding is that it's about $500 a year. So the cost is fairly minimal on that in that aspect. And I think that's all I have. I tried to hit all the high points quickly so we let you get on with your meeting.
Thank you, Courtney. We appreciate that. I'll open it up to questions. Jackie, thank you.
Hi, Courtney. Thank you. Could you talk a little bit about what you look for in admission criteria to the program?
Sure, that's a good question, and one that I skipped over. So the students they go through their first year, as I mentioned, and they apply at the end of the first year. The students have to graduate the program with a minimum of a 3.0 GPA. That was something that the Supreme Court felt very strongly about. So that is one factor, but that's only one of many factors. We have on the committee, it's a committee of faculty and the dean of students. And we interview all of the 1L faculty members on the students who've applied. And we look at creating, it's almost like a sports team, mostly because it's only 24 students. And they work together so closely for the 2 years that the dynamic is really important. And so we look for students who are willing to and interested in working with a group who values simulated learning. And we hope to get a diverse and dynamic group that has different strengths. We had, I think, to get some buy-in early on, we included the word honors in the title of the program. It's the Daniel Webster Scholar Honors Program, but really that is only one very small component of the selection criteria.
Thank you. And Neil?
This is just a very quick question, and you don't have to answer it now. You can maybe just even email the group. But I'm just curious, how many students have gone through the program total, and what's their admission rate?
So that's I skipped over that too. So there have been 270 students who have graduated through the program. There was only one who didn't make it through the program. We've had, I think, over the course of the program, 14 who've dropped out for various reasons during the program, but on their own, not that they didn't complete the program successfully. And I will tell you that those students who dropped out tend to be students who figured that they wanted to take a bar exam anyway and wanted to leave the state for a full-time externship. And at the time, we're looking at this very differently now, but it used to be required that the students stayed in New Hampshire for the full 2 years. We're changing that. We're allowing remote participation in the capstone for the third year to open up the flexibility of students going out of state for externships.
Thank you. Alex?
Hello, can you hear me?
Yes.
Oh, great. Hi, Courtney, how are you? I have a quick question. Do you foresee any scaling problem if somehow this class were to be expanded from, let's say, a class of 20 to a class of 100? What types of scaling problems do you foresee such that another institution, for example, were to copy or mimic a similar infrastructure, that they may experience problems that might not be appropriate for a bigger class?
So I think the thing that makes scalability difficult on our end is how detailed the simulations are and how many volunteers we have engaged in the simulations along the way. So mimicking the program as it is now and expanding it to a larger number would be very difficult to just find all of the interested witnesses and court reporters and judges and things like that. But using the basics of a curricular model with portfolio and then a bar examiner review, I think is scalable. I think that it's important to have a director of a program like that at each of the law schools to help facilitate both the curriculum and the portfolio compilation. And as a counterpart with whoever it is that would be the administrator of the program. For us, it's both the Board of Bar Examiners and the Supreme Court that I answer to on a regular basis. But I spend a lot of my time working with outside constituencies, teaching classes, and trying to make improvements to the program. And I think resources at the law school level is probably the biggest thing that you would need to make it scalable.
Thank you. And Alex, you have your hand raised. I'm not sure if you have an additional question.
Oh, no, I don't. Thank you so much. Please say hi to John Garvey for me.
Will do.
Thank you, Courtney. It sounds like a really fascinating program that you have, and I appreciate you sharing your time here to present to our group.
Thank you.
We do have a change in the agenda. The Oregon presenters, we will need to reschedule just given the time and their prior commitments. So we'll go on now to the next item on the agenda to discuss the approach that's used in Wisconsin with the diploma privilege as one of the alternatives, so that the students are automatically admitted without having to pass a bar exam. And we have Jacqueline Rothstein, the Executive Director and General Counsel of the Wisconsin Board of Bar Examiners, to discuss with us.
Hey, Justice Guerrero.
Yeah.
Before we get to the Wisconsin Diploma Privilege presentation. I just, Joanna from the Oregon Task Force is still on. I just want to tell her thank you.
Oh,
for
I'm sorry.
hanging on.
I thought she had left, and I would also like to thank her. I apologize for getting off track on scheduling, and really, we do hope to ask you back if you're willing to come and speak with us again.
And I was very much looking forward to it and would love to come back. My 6-year-old will disown me if I don't make it to soccer practice.
I understand that.
Thank you all so much. And Dean Galini was also on. He has to catch a flight, but we would both love to come back another time.
Thank you both, and we really do appreciate your flexibility. I'm sorry about that.
Thank you.
Good luck at
pleasure. Thank
soccer.
you.
Thank you. Okay, and do we have Jacqueline on?
I am on. Can you hear me all right?
We can, thank you.
Well, hello to everyone this afternoon, and thank you for inviting me in to participate in this study of yours and share the information from Wisconsin with you. I am Wisconsin born and bred, and I am the 3rd generation in my family to have received the Wisconsin diploma privilege. So I have a fair amount of experience with it and understanding. I've been the executive director and general counsel in Wisconsin since 2010. Next slide, please. Today, there are a number of items that I intend to cover with you, beginning with the brief history of the diploma privilege, followed by our applicable Supreme Court rules, how it actually operates in our state. I'm also going to provide you with some relevant statistics and advantages of it. I will also share what our experience has been with regard to the privilege and how that connects to attorney discipline. There's one case in particular in which the diploma privilege was litigated, and I'll tell you briefly about that. I will also discuss how reciprocity with the privilege works, and I will share some final thoughts followed by an opportunity to answer any questions you may have with regard to the privilege. Next slide, please. So a little bit about the historical background of the diploma privilege. It is not an invention that was created here in Wisconsin, but it did here, as it did in several other states, increase the standards of practice. Although we are the last American holdout of it, as I said, we didn't create it. Since 1842, there were 32 states and the District of Columbia that have granted some form of a diploma privilege. And in fact, as late as 1977, there were still 5 states that retained it. We are indeed the last one standing, although interestingly, and some of you may already know this, in response to the COVID-19 pandemic, Utah offered a temporary hybrid, as did Washington. And during this pandemic, other attempts have been made by various law student organizations and some law school faculty for similar measures. Many of those did not succeed. Minnesota, for example, our neighbor to the west, their Supreme Court declined to adopt the diploma privilege despite a petition before them to do that. And Oregon also declined to adopt it after they studied it. Next slide, please. So historically, there have been 3 primary types of the diploma privilege. And the first one is what is often referred to as the universal form, which allowed admission into the practice for graduates of any law school within the United States. The second form, known as a statewide form, allowed graduates of any school within a particular state to ultimately achieve the diploma privilege. And then finally, the state law school, and this is certainly how it works in our jurisdiction, provides the opportunity for graduates of that jurisdiction's in-state law schools to be admitted. Next slide, please. So in 1971, the Wisconsin diploma privilege took a stricter turn, and that occurred when we adopted what we refer to here as the 30 credit rule and its companion 60 credit rule. And students who attend either Marquette University Law School or the University of Wisconsin Law School here in Madison have to take and complete not less than 84 semester credits. I will tell you that as a practical matter, both schools require 90 credits. But of those 84 credits, 60 of them are a combination of mandatory and elective credits. And within that 60, 30 credits have to be in 10 designated subject areas, which we'll talk about in just a moment. Next slide, please. So our rules require that not less than 60 half semester credits have to be earned in mandatory and elective subject areas, and that not less than 30 of those 60 have to be in particular subject areas. So if you would kindly turn to the next slide, please. These are the particular topics, the 10 topics included in 40.03 that students are required to take and complete. They're pretty obvious, pretty self-evident: con law, contracts, criminal law and procedure, evidence, jurisdiction of courts, EPR, pleading and practice, real property, torts, wills, and estates. I took all of those, I can assure you. Next slide, please. So how does this privilege actually work in our jurisdiction? Students who anticipate a May graduation date, and that really is the majority of them, are eligible to apply for admission in our state beginning in October of the preceding year of their anticipated May graduation. They have to file, so I should say, somebody who is planning to graduate in May of 2022 can file his or her application as early as October of 2021. We require an application, an authorization and release, and a fee. If you file after December 1st, a late fee is charged. All applications undergo a character and fitness investigation. And I think what's really important to note here, because I think this is sometimes overlooked, is that graduation from a Wisconsin law school does not automatically guarantee a right of admission. So for example, if you didn't take all of the required courses under the privilege, you wouldn't be eligible to receive it. And some students, for reasons that I can't explain and don't really understand, choose not to take all of the required DP courses. If they didn't get the required GPA by their schools, that would also potentially prevent them from receiving the privilege. And finally, and this is not uncommon, but it doesn't happen a lot either, certification can be denied based on character and fitness issues that come up during our investigation. Next slide, please. People are often curious about what our statistics look like and what the advantages we see of it are. So I just want to share a few of those items with you. So statistically, we typically admit about 51% through the diploma privilege, 19% via the Wisconsin bar exam, and finally 30% based on proof of practice or on motion. It's sometimes called in other jurisdictions. We see a number of advantages associated with the diploma privilege. To begin, none of the people who are eligible for it take a bar exam. So obviously there's a lower cost to students who graduate from one of our in-state schools. Our graduates do tend to stay in our state. And our Wisconsin law schools most certainly tend to be more directly involved in our local and statewide legal communities. And it really does have a tendency, I have to say, to foster a closer relationship between our judiciary, our bar, and our law schools. Next slide, please. But in addition to those advantages, people often wonder, well, what about your discipline